Yes.
May I please?
Yes.
My lord, on behalf of learned senior counsel Mr. M.Z. Ahmed, I beg to mention item number 32. My lord, he is out of session. Concern of the office for the second.
Okay.
Kindly, Madam Adjan, for the
32. On the prayer of the respondent, number 2.
May I please? I beg to mention item number 33, my lord.
33 has
My lord, this matter has been accepted. Order has been complied.
complied it. Huh? Order complied.
Okay, item number 3 also. I need number.
2015.
Lordship, it is method lordship, MR Pasok. MR lordship, MR Adhikari is there. Council lordship, his father is in a hospital.
His name is not there.
MR Adhikari. Item number 3.
Item number 3.
Yeah.
Okay. On the prayer of the petitioner.
It is
Yeah.
mention item number 15.
50.
15, 1, 5.
Yes.
That-
Yes. Petitioner.
May it please, Your Lordship.
Yeah.
So I beg to mention for listing of a writ petition, Lordship, the matter pertains to, Lordship, that person from Cultural Affairs Department, no suspension order was released, issued, and Lordship, no salary is doing on that day, Lordship was heard, and state was required to file affidavit in after 10 days. Lordship asked me to, when I asked for to fix it, Lordship asked to make a mention.
Make a mention, then he will make a mention in that court. Senior judge. Yes. Next case.
May I please?
Yes.
May it please the Lordship. Lordship, with the consent of the adversary, I beg to mention item number 42. In this case, we have to file an affidavit, and affidavit has sent for vetting, but Lordship,
On the prayer of the respondent number.
Agriculture Department.
Respondent agriculture department.
Hello.
May I please?
All after TV. Yes.
But I am praying for listing of the rate. My lord, similar matter is 6 of 21.
Go to the senior bench.
May I please the Lordship? Lordship, I beg to mention item number 18, with consent of the other side, Lordship, on behalf of Jamie Chaudhary, kindly adjourn the matter for the day.
Adjourn. Petitioner. Petitioner adjourn. Item 18.
May I please, Lordship? I beg to mention for item number 20.
20. Yes.
Due to physical illness, learned arguing counsel not able to
Petitioner
petition.
adjourn.
May I please the Lordship? Lordship, I beg to mention item number 7.
Yes.
The senior counsel, Mr. H. Rahman, he is severely ill.
Petitioner adjourn.
May I please?
Hmm.
Lordship, item number 46, actually adjourn the matter for the and counsel out.
Item number?
Lordship, 46.
Supplementary or what?
Yes, sir.
Who made a mention? Who made mention for listing this case? Then why you want an adjournment?
Only adjourn the matter for the
6 weeks.
May it please the Lordship, I beg to mention for listing of a IA for modification of order passed in a PA number 340.
By this court?
Yes.
Yes. Yes. When today?
Uh,
You are for the petitioner respondent? Yes.
can I pay for a fixed date?
No. 3 weeks. You cannot have both. You'll give.
My friend.
You have given a consent.
No, I.
Oh, then say that I have no consent. You will argue.
In fact, so he is not well, my lord, my friend.
So that will be difficult. They have all fixed these day methods. Even more methods are mentioned. We allowed and they are taken. This is not. Yes. Yes.
Contempt case, my lord. Page number 136.
Page
136.
That's from 135.
Page 138. What is this? Tell us.
Regarding my lot, GPF and my old pension scheme for the secondary ticket. Directions there. The respondents are therefore directed to pass the appropriate constitutional directions, thereby granting the benefit of the applicant.
Where it is except it is 28 and 30.
Yes, all other
How do you know that? Where is the statement?
the names are there.
That here. Where is that petition? Cost?
This is my lot, the or
Where have you intimated them?
intimation my lot, page number one last page my lot, 137. The postal receipt is at page 118.
Huh?
Postal receipt at 118 and
Oh,
application
postal receipt will not do. Where is postal receipt?
118 in the epic.
Hmm?
Epic in the page number 118.
118?
Yes.
No, 118 is something different.
Application is at 137 and the application sent by the by speed post my lot. Postal
We have got an application at 137.
yes. The application receipt, my postal receipt is epic in page number 118.
118.
Yes.
118 is something different.
One it's the order of the IAM.
118.
Yes.
118 starts with Guwahati High Court.
Yes. There you can epic the my lot postal receipt my lot in the right.
Where is your statement that this has duly been received? Why have you filed this petition like this?
It is a common judgment, my lord. The common judgment.
Why both sides?
Both sides now it is accepted. That is a big petition. That is also
Accepted both sides. High Court rule has modified. So what?
yes, it's accepted now.
I'm not aware.
Yes,
Which rule? Accepted.
yes, yes.
Now show us your statement.
Page 7, my lord. 8, my lord. Common.
Where is the acknowledgement? Receive acknowledgement.
Acknowledgement by postal receipt, page number 150.
That is postal receive is not an acknowledgement. What do you say?
It's sent by post.
Where is that death has duly been served? Give us the statement. Show us the statement. Mister, you are in a contempt jurisdiction.
Statement paragraph 5 my written, madam.
Yes. That though the customers have acknowledged. Where is the acknowledgement?
If I see to this section.
The petitioner is permitted to file affidavit to show that the order alleged to have been complied by the respondent has duly been served upon the aforesaid respondent. List after petition. This is not the way contempt. Yes, next.
May it please your lord. This is a for 39 bail application. So second time, OAC is already released on bail. Last petition lordship has directed the public prosecutor to obtain inspection whether further custody is required or not.
No search sheet file.
No lord,
Yes.
already 14 days.
TT not received. Here we have written calling for TT.
On 22nd.
Madam.
Otherwise, lordship, the contraband recovered from Laila Begum lordship, it's there. Lalima Khatun,
Hmm.
from Lalima Khatun.
What Lalima?
Lordship, the contraband recovered from that accused, not from this petition.
Where do you get that?
That is on page lordship 25. Lord.
Your husband.
No, lordship,
No,
not.
You are the husband of Laima. Is that it? How?
I remember that case.
Ah.
He used to bring that contraband from
But
Ah.
lordship, that nothing was recovered from this petitioner. Lord.
Recovered from where?
Recovered from lordship, it is from the Lalima lordship.
Lalima or Lalima's house?
Yeah,
was house,
it
right?
is from Lalima lordship. They said it is in the house of the present petitioner, but it is recovered from the Lalima.
So far I recall it is your house
Yes,
and
lordship.
Lalima is your something.
Wife.
Lalima is your wife.
Lordship, Lalima is not my wife, Lordship. Abdul Basar, Lordship, Lalima's order, Lordship, will find on 28, Lordship.
Now this legacy continues to this bench. Now I understand.
Considering the Lordship, the length of detention, Lordship, 41 days.
This is order of
Page 28 for the co-accused.
you are Mubarak.
I am Mubarak.
See the order. The
Yes, Lordship, that
page 29,
Yes,
we
Lord.
granted bail. That's they are behind bar for last 51 days.
yes, Lord.
Mubarak Ali has been arrested. The prime accused Mubarak has been arrested recently.
Lordship,
So at least 51 days you deserve.
Lordship, contraband has not been recovered from this.
We'll see there.
That Lordship,
Yes,
Chancery,
22nd.
Lordship,
22nd.
22nd.
highly obliged.
That it is Dhirubhai 23 case in Delhi, not proximate, and that too, my lord, the victim should have been the
It
assistant.
is there.
It is.
This case we might consider.
Fine.
Not sure.
Yes, yes.
Not sure. We'll consider.
Actually, money was demanded by this Sanjay Shah and Santosh.
We'll see.
And my lord,
I think
one can I-
till now. Yes, you
can I
please-
say, my lord?
Yes.
My lord, possibly, my lord, the learned public prosecutor, when it was rejected, my lord, there possibly wrong information was put that my mobile connectivity was there. That is absolutely untrue, my lord. It has been sent to FSF that day itself, my lord. But my lord, it has not come. Now it has come or not, I do not know, my lord. My lord, that part is, and secondly, my lord, the victim should have been the lazy, my. And we have stated everything in page 10, para
Yes,
6,
10.
page 10,
Page
para
10.
16. Okay. And my lord,
We'll
Yeah.
consider definitely, but we'll go after going through the city.
yes, yes,
Please, then that is a
Yes.
slippery wicket
my
because
lord,
the
only,
the second.
yes, yes. And my lord, of course, absolutely academic, my lord. This
Give
is-
us, it
this
will
is-
help us.
23, my lord.
Yes.
That is right. Exactly opposite.
We'll see, may not be possible today.
Yes, yeah, any convenience.
We'll see.
My lord, that character I should not have marked, my lord. I have marked it.
No,
my
no,
lord.
no
It is
issue.
not-
There no issue.
No, 23. Okay.
In fact, I passed the judgment in a different case, even quashing the entire procedure.
Exactly, my lord. Yes, my lord. Yes. So I should get, my lord, exactly. My lord. Yes. Yes. Highly obliged.
We'll see.
My lord, my lord.
Yes.
Lordship relied on Arnab Goswami case.
No. I think some,
Yes,
I forgot.
Lordship
Mr. Mahajan was also there.
yeah, lordship authority is that. No, I was not there, but I was sitting nearby. Lordship authority. Yes.
Sir, 49 also city not
How many days? Oh, AB.
heavy.
302.
After
Twen-
visit,
22nd or after vacation?
after vacation immediately. Fifth of
Give a date.
Please, your lordship.
Yes.
31 met. My lord, order is page, my lord, 9. Operating party page,
IA.
no, my lord, page 31 met.
No. What about the respondent service and all?
I feel that.
3, 4, 9, 10. Respondent 30. Item number 30, isn't it? 30 and 31.
31.
Who is for 30?
30.
My lord, this contempt case 582.
Hmm.
My lord will peruse the order dated 15/9/23.
15-9.
15/9/23, the last order, my lord.
हाँ.
My lord, this para 4 of the order, my lord, the last page.
Hmm.
My lord, I was requested by this court to appear on behalf of the respondent.
हाँ.
So,
They have directed to issue copy.
yes, till now I am waiting for the copy, my lord. Actually, without the copy, it has become a little difficult for me to obtain the instructions, my lord.
It's true. You have been roped in by us. How will you get a copy? Cannot blame me.
So for my lord, I know this has been complied. Was in a different case, but I have to get the written instruction on the basis once I get the copy of the contempt petition. Ma'am.
Nothing is there in this contempt petition.
I think, my lord, that has been complied.
See, it's general thing that social welfare department will be the nodal department, shall verify the position of prisoner vis-a-vis the selection process and proceed with their appointment in terms of their position.
Exactly, my lord. So far I remember, my lord, there was a selection and one speaking order was also passed by the department, social welfare. So, my lord, I was not aware of the exact issue, my lord, because of the absence of the contempt
Okay.
petition.
This court, under its order dated 15/9/2023, directed the learned counsel for the petitioner to furnish sufficient copies of the petition to Mr. Dhar so as to enable Mr. Dhar to obtain the required instruction from the respondents. When the matter is called today, none appears for the petition, though Mr. Dhar is present. Mr. Dhar submits that he has not been served with the copies of the contempt petition, therefore he could not obtain instruction as directed. In that view of the matter, the present contempt petition stands adjourned for 6 weeks. Stands adjourned and be listed as and when a mention is made. Yes, 31. 31 separate video.
May I please your lordship. Well, judgment and order, well, of the page 9.
Yes.
Operating
The space
page 9, that is, operating party page 14,
is
14. There are 24 and
proposal.
yes, my lord, has been passed in 2016. Contempt and 2000. No, this is with
Understand, but can we compel them to legislate?
exactly. Well, that issue has already been noted.
Uh-huh.
That issue has already decided. Because earlier my friend raised objection, after today objection.
Government should consider giving
Well-
promotional avenues, anything.
Well,
I think they get SCP,
Yeah, no,
SCPS.
my lord, there is a category of employees in the revenue department
Mm.
known as, my lord,
Extra writer.
extra writers. Now, there were issues raised by the petitioners herein on account of, my lord, their promotional stagnation and
Mm.
service career benefits. All these, my lord, issues were raised. Finally, this honorable court, by this order, my lord, had disposed of that petition, thereby giving a leeway to the government that a middle way has to be found out. Now, people kindly see.
I've seen that. Middle East we found out,
Yes.
a new post may be created which
Yes.
should have a higher pay scale than the extra writers, which would enable the extra writers to be promoted to the next high court. Indeed, the state government would have to consider modifying 2010.
Absolutely.
It's a case of consideration.
Now,
Now it's 24 is that reasons the state government should consider giving provisional appearance to the extra writers within the framework of 2010 rules or within the registration department.
Yes, sir. Now, pursuant thereto, my lord, the government has already taken up the action of, my lord, enacting a new set of rules.
Hmm.
That draft rules, my lord, was already placed before the finance department. Finance department gave concurrence with certain conditions and directed the revenue department to take the views of the personnel department.
Okay.
And was moved to the personnel. Everything is there on affidavit, my lord. In fact, the present respondent number 6, whom I am representing, is the principal secretary of the revenue department, who is the highest authority.
Mm.
He has filed one detailed affidavit, my lord. Thereafter, an additional affidavit has also been filed. That, my lord, will file.
What is your status?
Now, my lord, the matter is pending before the personnel department. Once the personnel department views are obtained, matter-
Expedite it.
yes,
You consider if you can give it, or you can give SCPS and
Lordship will kindly appreciate. We are going to frame the rules. Once the views of the personnel departments are received, matter will be placed before the state cabinet. That's it. And that has been specifically pleaded in the affidavit. 2 affidavits have been filed, one after another.
to expedite 6 months is given. We will not force you for the time immediately.
Yes.
But you advise your client that it should be done.
My lord, there already, my lord, pursuing the matter, following up the matter with the personnel department. But personnel department was not was a party. They have not, my lord, got hold of those personnel department. Now, since the ball is on us, my lord, in our court.
You have done your part.
Yes, yes. Constable, kindly adjourn this matter for 4 weeks, my lord. Let me come up with the updated instruction. It is
Okay.
not that, my lord, that things will not be done. Things are moving.
Mr. Bapujari, learned counsel for the
Respondent number 6, my lord.
respondent number 6 submits that pursuant to the sports order dated 9/11/2016,
my lord,
a proposal for amendment of the rule so as to create avenues for promotion of the to the extra writers has been initiated, and the state proposal is pending before the personnel department at this stage.
yes, personnel
stop.
B department.
Personnel B department at
department.
this stage.
Yes.
He further submitted, since the exercise carried out is for the purpose of modification of a rule,
Modification as well as, my lord, enactment of new rule,
modification as well as enactment of new rules,
my lord.
it is taking some time and could not be completed
Mhm.
within the stipulated period of 6 months. Therefore, Mr. Borpujari contends that this matter may be adjourned for 4 weeks to enable him to obtain the further instruction and regarding the status of implementation of the order in question. Full stop. This court is also of the view that as the matter pertains to uh, enactment of new rules or amendment of the existing rules, that the said process may require further time, and the petitioner and the respondent has already initiated the process at their end, which is pending before the personnel B department. Accordingly, matter stands adjourned and be listed after 4 weeks, on which date Mr. Borpujari shall apprise this court,
I will furnish the updated status.
apprise this court and furnish the updated status of compliance.
I'm so obliged.
Certain things, Mr. There is a 6 months rule is no doubt 2006 pending, but ultimately it's not as mandamus that
Yes, technically it is not a mandamus per se.
per se.
Till then, my lord, department has swung into
They
action.
can say no possibilities. They are getting SCP's
They
matter.
will be benefited, my lord. Only
So wait
it's
for
a
some
matter
time.
of time, my lord. I'm so obliged. Really obliged.
Yeah, please. Miss the item number 35.
You have missed the
Yes.
30 and it has gone to after 6 weeks.
Pilot our name recorded.
How can we record your name? We are on live streaming. You were not here.
Pilot.
How
No
can we
problem.
record that you are present? We have dictated the order. Earlier it was possible. Now it's not possible.
Apply.
None appears for the petitioner court. List after 6 weeks.
Okay, in this matter, we received the instruction.
Yes, Gogoi, what is
Okay,
it?
we have received instruction. The issue here is that we couldn't process the pension paper because the petitioner didn't serve us with a certified copy of the order, your lordship.
Which order?
This High Court's order, your lordship. The last page of the contempt, your lordship. Page 13, your lordship. Down below, it may be seen, your lordship. Page number 13 of the contempt petition. Contact the petitioner and get the copy of the court order, your lordship.
You are for?
I'm for respondent.
Yes, no. In
Respond number
original writ petition, which one is your department?
the irrigation department, Lordship.
Hmm?
Irrigation.
N. Upadhyay was duly represented.
He was there, Lordship.
Then
In this matter, Mr.
it's a
P. N.
pension matter. Do you know that you want a copy to be served?
Thereafter, we received the copy from the AG. We have forwarded everything to the AG, Your Lordship.
Tell us that we have done something.
have
Don't
done
say
something.
that copy is not serving, therefore we cannot
Then
comply.
I'm just
It's a pension matter.
yes, sir, Lord. The delay was due to non-sufficient copy. Thereafter, we received from the AG. and we have
Okay,
forwarded-
now what is your stand?
we have forwarded the every pension paper to AG on 73, 2021, Your Lord.
Okay. Mr. Gogoi, Learned Council appearing for
Respond number 1, Your Lordship.
respondent number 1 submits that the pension paper of the petitioner has been prepared in terms of this court order dated 17/6/2020, passed in WPC 2507/2020, and same has been forwarded
To
to
the
the
AG.
Accountant General within bracket A and E. Isn't it?
Yes, sir, Lord.
A and E. And awaiting response from the aforesaid authority. Full stop. In view of such submission, Mr. Gogoi is permitted to file an affidavit incorporating the aforesaid facts with an updated status of the consideration of the case of the full stop. Please this matter after 3 weeks on a date to be fixed by registry, on which date such affidavit shall be filed.
Obliged, Lord.
Please, Your Lordship. Lordship, this order has been complied with.
Complied with
Lordship.
the Learned Council. What is the order?
By the order dated 25/8/2022, passed by the director.
None appears for the petitioner and call. Come on. By the order dated 16/7/2018, passed in 4684 of 2015, the Director of Social Welfare Department, Government of Assam, was directed to cause an inquiry about the residential status of the petitioner and the respondent number 6 in the writ petition. In terms of the aforesaid order, an inquiry was conducted and the director has passed an order on 25th of August 2020, whereby claim of the claim of the petitioner, 2022, and the claim of the petitioner was rejected and the respondent number 6 in the writ petition was allowed to continue as Anganwadi worker. That being the position, the contempt, the order in question has been complied with. Full stop. A copy of the order dated 25th of August 2022 is kept on record and marked as document X. The petitioner shall be at liberty to assail such order if agreed. Contempt. Okay, to answer Nambila. Just give the slips who are appearing for whom. Dispose of.
Submission, Lordship. In item number 36, Lordship. This order is complied. I was in court number 5, Lordship.
Okay. Okay. Petitioner, Learned Council for the petition submission, order has been complied.
Better maybe.
There is also this order has been complied. We have approached the Supreme Court. The Supreme Court has passed the order.
What is the order?
After filing of the contempt, we have approached the Supreme Court. Supreme Court has set aside the order passed by the division. They were party.
Uh, now, have you implemented the subsequent part?
Yes.
Where is that?
They were
There is no, the Honorable Apex Court has not absolutely satisfied. Some relief has been granted. Whether you have paid those? Where is that?
still by them.
You file an affidavit. You are a for?
And for the bank, Indian Institute of Bank,
No. Respondent number?
on number 1.
The learned counsel for the respondent number 1.
Some development happened. Also.
Huh?
Some development has happened. Prabhashan Chakraborty has remitted his office.
Anyway, you learned
new-
counsel, you file an affidavit.
Yes.
Learned counsel for the respondent number 1. Grace foreign is granted 3 weeks time to file affidavit.
Okay.
You give a copy to, you keep it. Motion.
Obliged.
The complaint ground upon Gadi. File a petition and it was directed to consider our case. And
This is read petition or what?
it
Huh?
then yes, then we file a contempt petition. Contempt says if you place the matter before that means that authority direction was given to place the matter before that. We have done the same order, push the order Miller, submitted, but nothing has done. Last contempt order Miller, kindly check today, that is your kindly page 23. Page 23. Order by the Honorable Court.
Page 23.
11%, 24. Last
This is 23 is contempt case.
contempt. Last 24, last line Miller. Direct counsel for the prisoner submit that despite the DLC responding the case of the prisoner, the self yet to consider the case of the petitioner in as much as the SLC is yet to have.
Okay, then what happened thereafter?
Captain Miller, we have submitted this petition Miller, this order Miller, but not. Next is Miller, page 26, we have submitted.
Yes, obtain instruction, what happened?
Lordship, I have obtained instructions.
Hmm.
The SLC minus the SLC was dated 31/12/2018. Still, his case was considered and he was not recommended. If we go by the page 24 order also,
Where is the order in contempt?
at page number 24, Lordship. So, Lordship,
Problem is this, you do not intimate these people. That's why all this unnecessary litigation. See, she was awaiting that my case is not considered. On that and that backdrop, a writ petition was filed, order was issued, then he files a contempt. You do not appreciate the court that yes, order was taken note. Instead of concluding the contempt, there are another mandamus in the contempt itself.
concerned department is the P.
File an affidavit. Bring it.
Is the concerned department.
File it.
PLC Millard found one post was noted for, and SLC Millard
But your case is rejected. Now this is let him bring on record so that you can do your. There must be end to all everything.
Right.
Learned counsel for the petitioner. Respondent, state respondent. Praise for an is granted. 3 weeks time to file affidavit.
Lordship,
File it, give it, return back. Return back the. Yes,
maybe a date can
give.
Petition for file. They want that for
We'll see. Therefore, that is he let him bring on record that it was in fact did not have the opportunity to intimate it. That statement is required, is not it? That's why you'll have to file an affidavit. We cannot pass order on
26 January.
26th of them.
So,
Holiday.
sorry,
You want to come?
30. There is no holiday. Anyway, last 30.
30th of them.
got to take some instruction from my client. Let it be listed after vacation.
What instruction you need?
But for long, the matter was not listed. What is the updated position?
We'll go by the pleadings. What did you say?
So we file our affidavit.
What did you say?
It stated that the APDCL has its own mechanism in place, as far as compassionate appointment is concerned. There is an office order in 2005 which will perhaps be applicable to the petitioner, and that office order carves out an exception, Malad. The Malad may kindly take up the affidavit filed by the APDCL, Malad. Page 7 of the affidavit contains the office order. Second paragraph. The existing provision of appointment on compassionate grounds shall be limited to the following.
Space.
7 of the affidavit.
It starts with some power to say to whom it may concern.
To whom?
Is it certified?
The affidavit dated 10th January 2020.
Affidavit there are under affidavit.
There are 2 affidavits. This is filed by one Chandran Sharma.
Okay, 7.
The office order of 30th April 2005. Second paragraph, the existing provision of appointment on compassionate grounds shall be limited to the following cases only prospective.
Two categories, not
Two
for
categories.
all.
Serving employees killed due to extremist violence while on board duty. That of the employee due to accident or mishap while being on board. Here, the deceased person, was not killed due to extremist violence, or he did not die due to an accident while on being duty of the APD.
How he died?
He was not keeping well. He died at his residence, on 24th June 2012. The next page thereafter, page 8.
Page 8.
With reference to the I'm informing you that late Kanuram Rabha died on 24th June 2012 during his service career. He was attending his duty till 20th June 2012. After that, he remained in his residence and died on 24th June 2012 due to it.
When he died?
24th June 2012. 24th June 2012.
2012.
And the scheme, is no longer available. Compassionate appointment has been replaced by compassionate family.
Did you give him family pension?
They are perhaps already drawing pension. He was an employee of the.
Okay, Mr. Rava.
I was waiting for instructions.
What kind of instructions? He will say that I want a job. That instruction he will give. Isn't it?
Updated.
What updated information? The fact that his father died in the year 2012, no dispute. The fact that they are having the scheme for a limited person. There is no dispute. The fact that we are in the year 2023, isn't it? Let it end. Let it end here. All hopes and aspirations.
Not communicate with the client.
They will not communicate. We have also given a part, Mr. Rava Learned Counsel. So far, so good. The present petition under Article 226 of the Constitution of India is filed assailing assailing that petitioner has been illegally, arbitrary, and unreasonably denied appointment on compassionate ground, inasmuch as the father of the petitioner, who was an employee under APDECL, expired on
24th June 2012.
24th June 2012. Full stop. According to the petitioner, due to sudden demise of the father of the petitioner, the state of entire family had become pitiable, as there was no source of income. Accordingly, the petitioner approached the APDCL authority and duly applied before the APDCL for appointment on compensatory ground through his application dated 30/11/2022, addressed to the General Manager, LAEDCL, Gwalpara Division, Gwalpara. Through such communication was forwarded by the Assistant General Manager. However, his case was not considered by the respondent authorities. It is the case of the petitioner that he is entitled for compassionate appointment in terms of Office Memorandum dated 9/9/1983 of the State of Assam. Per contra, Mr. Gogoi Learned Counsel submits that the APDCL is a public limited corporation, company constituted under the Electricity Act
2003.
2003, and they have adopted and having their own policy of compassionate appointment. And in terms of said policy issued on 30th of April 2005, those serving employees who killed due to extremist violence while on board's duty, the family of those employees serving, families of those employees serving, families of those serving employees killed due to extremist violence while on board's duty, and family of those employees whose death occasioned due to accident or mishap while on the board's duty. And therefore, the case of the petitioner for compassionate appointment could not be considered as he did not come within the parameters as laid down in the aforesaid policy, inasmuch as he was attending his duties till 28th of June 2012 and remained in his residence due to illness and died on 24/6/2012. The Who is this Hitesh Chandra Rava? An affidavit has been filed.
Additional affidavit was filed. Pursuant to an order of the Honorable Court as to whether or not the APDCL scheme will reign over the otherwise
Ah.
the OM of the government.
The respondents filed another affidavit in opposition in terms of its court's order dated 20/02/2020, whereby a clarification was sought on the issue whether or not the case of the petitioner would be covered by the office memorandum dated 9/9/83 issued by the Secretary to the Government of Assam, Department of Personnel B. Digital Personnel B. A specific stand was taken in the affidavit that memorandum dated 9/9/1883 is applicable only to the state government employees in concern. I mean, STEM is not followed by the respondent from APDCL as it is having its own scheme of compassionate appointment. It is seen that the order of the petitioner expired on 2020. The principle of compassionate appointment has been reiterated by the Honorable Apex Court in the case of State of West Bengal versus Devakar Tiwari versus State of West Bengal, reported in Pencho, which is quoted here in below. In the case in no, I'm having in the modification. In the case in hand, the immediacy as advises in the aforesaid judgment is not available. Not only that, under the scheme of the employer, there is no scope for a issuance of any direction to consider the case of the petitioner, where the policy itself do not cover the case of the petitioner. In view of the aforesaid, the present petition is dismissed. The parties to BRD.
Deeply.
Yes, Mr. Das.
The point involved here is that my services were terminated on the basis of conviction. And that particular, my conviction,
Mm.
impugn order which was passed
Mm.
by the government,
Mm.
it was put to challenge before the Congress.
Mm.
And we said, my borrowing authority is the Karbi Anglong Autonomous Council. So how the state has
Power.
issued this impugn order?
Mm.
On this limited ground, there was a stay order of that termination. And subsequently, that moved on. Then ultimately, the High Court has passed a judgment whereby the conviction was set aside.
Okay.
So as on date,
There is no.
I am acquitted from that case, and my solely the notice which has been issued by them was conviction. Termination was based on conviction, so it doesn't remain as on. If that be the position, man, so wherever I was, so I should
It
be
should relate
restored
back.
to the
It should relate back to your original.
maybe suspension. It should relate back to. That's why limited case. Kindly see the impugn
What is the law in this regard?
law is very clear. There are few judgments. I'll just show my law. Before that, at page 29. This judgment.
When Mr. Mojumdar stands in the midst, there are some difficulties.
No,
Yes.
no difficulty. Only thing is, now the argument is that there is an acquittal in the appeal.
Mm.
So based on that, there should be an order of instant. So where is the order of acquittal on record?
I show it. There is judgment of
No,
the
if
High
your
Court.
lordship takes judicial notice, then it's a different thing.
Judicial.
Otherwise, on record, they have not.
Already we placed.
That is why I say.
No, I leave it to your lordship. I have a copy.
So
I have a
meaning-
copy.
Meaning thereby, we have to amend the writ
No.
petition.
That's a different thing.
That's
me-
what
at
we
least
mean.
Meaning thereby that matter should go to the go
No,
after vacating.
lordship will take it up today. I have got a
No,
copy.
no. If you are having a copy, if
I
you
have already
both
sent
both do not
What-
dispute.
Otherwise, I don't dispute. Otherwise, it will be brought on record. I'm not saying that.
That's correct. That's correct.
We brought
That's
it
what
record.
I'm saying.
We have
I have a copy where I'll argue from there.
No, I have brought it record. Court record.
By affidavit.
Because
No,
this was pointed out by on the last question also. I'm only on that.
This is the judgment.
Yes.
I have a copy.
I think we can take judicial notice of this judgment.
Considering the thickness.
This notice has been put to everybody. So we take judicial notice of this judgment. Now what to do? Then tell us.
If they have completed, I have got basically two subjects.
Tell us.
Legal.
Hmm.
Number one is, my lord,
I have not completed.
No. We have not allowed you to complete.
Lordship
Take
is
it.
asking, that's why
Ah,
otherwise I would not have.
No, you have completed, you said. What?
I'll have only two subjects.
Hmm.
First is, I'll show from the judgment itself
Hmm.
of acquittal that it is not an honorable act.
Okay, fine.
I'll refer to 2-3 paragraphs.
Okay, it's not an honorable act.
Number one. And number two, assuming that after the acquittal, there has to be an order of reinstatement, the authority has to be left to take a decision.
Of
The-
course.
Yes. On that one, I'll show 2-3 judgments. These two
Now,
latest-
suppose we'll come that we'll have this. I always want to have a bird's eye view so that we can
That's
go in
what I
deeper.
said.
Deeper.
Outline is
Suppose outline is that there is not. This is not an honorable acquittal.
Yeah.
Can that be a ground, or can that be a basis to straight away dismiss a person? This is one. Or do you need further inquiry or something like that? Because if you are basing on the dismissal only on the basis of conviction, then there is an acquittal, so conviction is gone. If you want to have a satisfaction that no, yes, there is conviction, but this is not an honorable, there is an acquittal, but this is not an honorable acquittal. Therefore, we still have a power to dismiss it.
so there.
Then
One
is
thing
it
you
permissible to straight away do on the basis of an acquittal order having, or you need to have a
Enquiry,
phrase?
no, but enquiry has already been initiated.
Uh,
That is pending.
so you continue the necessary, you will send him to the time when what was his position, he was in suspension, he'll
So,
continue to be in
so-
suspension.
So, in that regard, my submission will be,
Hmm.
Lord will consider these decisions of the Honorable Report and consider as to whether Lord will leave it to the discretion of the government to take it. My submission will be they will have to take it. That in view of
Uh.
these are the submissions that me.
Okay, yes, Mr. Tata.
No, I just give it.
So we have
I
limited
think
the scope.
I'm not asking
Hmm.
that I should be reinstated.
No, that
This is what I told at the very beginning,
Hmm.
where I was
Hmm.
placed under suspension.
that should be
If inquiry goes, it will go on. Absolutely no problem.
no problem.
How the apex court has decided in this issue, that has to be looked into.
Yes.
And whether the judgment speaks of honorably, the word use has been said. Kindly see one paragraph, I will show it. Paragraph 232 of the judgment. Only one paragraph.
230.
32 of the judgment. Internal page is 229. 230. 232. Internal page is 229. 230.
Internal page is
229. That is para 232. Para 232. That's the judgment. 232.
232.
Got it?
Hmm.
As a consequence, the impugned judgment dated 22/5/2017, passed by the learned special judge Nyay in special case number so does not stand to scrutiny and is hereby quashed and set aside. The accused appellant so did not prefer an appeal are all acquitted of the charge. However, it makes a finding requiring judgment shall not so and so the other crime if any registered so and so government fund so and so. My lord, I have understood in this case that entire judgment has been set aside and questioned. And if there is any other case that is left to the government. My lord, what more? Now, my lord, I will just tell your lordship. Now, kindly see.
You are the appellant in
In appellant,
What is your name?
my lord, R.S. Khan. That is, your lordship will find at page 32. Internal page 32. Page 32.
This judgment relates to you. It's a common judgment.
Yes, common judgment. It has been dealt, my lord, common judgment, but it dealt separately. This is at page 32.
Your thing is dealt with. Yes.
32. Start 32 at page 164.
No. Regarding your part. See,
Yes, my part.
suppose at page, if you come page 231,
Yes.
so far relating to some Warisa and Veneta. Consequently, you have no
My
hesitation.
lord, what the point?
Hmm.
It has been discussed. Finally, it
No,
is
we are not going
discussed.
to just this is my I
Yes.
do not know how it was there.
Yeah.
Page
Yeah.
2, paragraph 231.
1
231.
231.
We have not no hesitation in
Hmm.
holding that prosecution has miserably failed to bring home reliable, legal, and admissible evidence so as to prove the charges against the accused appellants beyond unreasonable doubt.
Yes.
Okay. Since we have concluded the prosecution
Yes,
failed
sir.
to prove commission of terrorist by so members, the charge under so. So this is in respect of these two person or all.
Which paragraph? my lord?
Paragraph 231.
32 is all.
231 is. Where is your paragraph?
Yes.
Let us see conclusion of your concluding paragraph.
My lord,
Here 231 is so far relating to these two persons. And 232 is a common for all.
common for all.
Common for all.
232 common for all. 231 so far
My lord.
relating to two persons.
Yes.
What is your paragraph?
Yes.
Individual paragraph?
Yes. 164.
Paragraph.
164.
Yeah.
Internet page,
Correct.
page 32 it starts.
Page 32.
2 it starts.
Correct.
32.
Hmm.
Internal page 32. And it starts from R.H. Khan at 164.
Page 164.
Yeah. 164 kindly see.
Page.
Page 32.
Page 32. Yes, page 32.
Yes. Thus the factors are now it's R.H. Khan. Got it?
Page 32.
32.
Arif Khan.
Here R.H. Khan. Thus the facts and circumstances of the circumstances appearing against the accused from the evidence discussed herein above. So and so. Your lordship wants the detail of it. It is page 197. So forget that 197.
Huh.
Para 197. See page 190, para 197. 197. 197. Lordship got it? Lordship got it?
Just
197.
a minute.
193. Internet
197. 197.
The appellant herein has been convicted as ever primary on the allegation.
No, this is
no.
okay. Khan.
Yes, Khan. The appellant herein ever has been convicted as ever primarily on the allegation facilitators who conspired with the accused so and so of the so and so with the aid and assistance to namely R.H. Khan. You also got it? And so. The firm of the appellant was granted antedated illegal work supply orders even though the firm license council had expired. The firms were not registered. Firm had no existence of given address. Advance checks were given and money was transferred to non-existing unlicensed firm being operated by so and so who withdrew the amount of check and thereafter facilitated the transfer thereof terrorist gang through Mohit Khojai for raising funds and for conversion of Indian currency US dollars for procuring arms and ammunition for continuing the terrorist act. Point for determination formula trial court against the accused person reiterated herein for the sake of ready reference. Whether the accused name first R.H. Khan so and so after formation of so and so after formation who entered into agreement with the members to do so and so. Now, my lord, 198. It may be noted that point number 9 and 10, 9 and 10 and 11 formulate a trial for virtually reiteration of point number 11, point or 9, and the same are not being reproduced. Ultimately, after discussing the evidence, trial court record is finding us against the appellant a paragraph says the impugned terms same are reproduced herein below, sake of ready reference. 371 unreserved who are remain during so and so, a nexus between so and so. So these discussed, my lord. Now 379, your lordship will discuss about. Then my lord will see at page 199. This is the argument where advanced on behalf of learned counsel, R.H. Khan and so and so, so and so. Now it goes on. Now at page 200, paragraph 200. We are of the view that a minute analysis and discussion of this finding is not required in this case because the prosecution did not propose any charges for criminal misappropriation, criminal breach of trust, cheating, fraud, and forgery against any of these accused appellants. Kindly see, my you got it? 200. It cannot be denied the allegation reproduced herein above would unquestionably give rise to the above offences. As has been mentioned above, the prosecution trial court took hands of this important aspect of the case by a lackluster observation that investigation this offence has been handed over to CBI. It admitted fact that not a single document pertaining to registration of case by CBI or the conclusion charges, if any, presented in the court concern against the accused appellant was brought on record of the present case. Now, the main thrust of proceeding allegation regarding this official R.H. Khan, so and so, facilitated the illegal transfer of funds to the firm accused appellant so and so by fraud and forgery, and thereby the funds meant for development activities NCH was siphoned off and routed to the members for funding it. All these financial irregularities, fraud and mis were done under the direction of so and so. All the accused have been acquitted by trial court of so and so under section so and so. Acquittal from this substantive offences were recorded on this so and so. Now kindly see 202. It is obvious, thus obvious, guilt of two public servants, R.H. Khan and the contractor so and so, has not been recorded for the actual substantive offences they allege committed, but by branding them to be conspiracy with the members of so and so, they were straight off convicted for the offence under section 2 without holding them guilty of the substantive offence which they allegedly committed for siphoning the funds from NCH counsel. Thus, before evaluating the prosecution case against this accused, issue which is required to be assessed beforehand is whether the prosecution may be barely able to prove beyond doubt that so and so a terrorist gang indulged in terrorist activity, which have to be funded by this illegal siphon of money with the aid and assistance of these five appellants. If the answer is negative, there will be no requirement to deal with the allegation against these five accused on the aspect of defalcation of funds of the NC Hill Council because the prosecution itself claims to have assigned this task to CBI. In addition thereof, to neither charges for substantive offences reflected allegation proposed to prosecution, nor were any charges framed by trial court. Expression of opinion by this court in the correctness of the allegation made against these five accused may prejudice the outcome of the CBI case raised in relation to very same allegation. However, strong doubt lurks on the veracity of the prosecution allegation that this amount were actually siphoned off in the precise manner alleged by the prosecution. Amount of so and so were found not collected with defalcated funds as held by trial court in paragraph.
Okay.
So this is an ultimate paragraph.
Page 228.
238. Now the position, I'll show you how the apex court dealt with this case, this number. The proposition of law is that once you are terminated on the basis of the conviction, and if it is acquitted, then what is the proposition? That's the only point to be decided. Now, see kindly, first I will show the judgment of Supreme Court 2012 SCC online Guwahati ISO 180.
2012.
SCC online Guwahati 1 ISO 1 Guwahati, thereafter I'll 188 paragraph 24. This your lordship will deal further later on, because this I'll deal later on this judgment, but I'll just try to place a judgment, latest judgment of the Supreme Court on this point. First proposition of law. 2021 Supreme Guwahati 594. paragraph 11 and paragraph 14.
5-9.
594. It is 594. Paragraph 11. 14. Paragraph 11. Para 11. May I read paragraph 11?
Mm.
We are of considered view as already been held by learned single judge when the writ petition finally executed by the High Court. Reading of the order dated 11/1/2018, by which he was acquitted, nowhere suggests that it is being done as a benefit of doubt or that it is not a clean acquittal. Under this circumstances, natural consequences could have been reinstatement in service of the writ petition. Go further down, my lord, paragraph 14. In this case, the facts are even better as admittedly there was no department proceeding against the writ petitioner private respondent 1. Here there is some departmental proceeding. The only ground for his dismissal for service was taken under the special provision contained in Rule 10 of the rule that has been convicted by the trial court. This fact no more exists now as he has been
Here
acquitted.
also dismissal was in exercise of that power.
That power, it is on
Department-
the basis of the conviction. Kindly see. That's why I was reading
Ah,
the order. Kindly.
dismissal is not on the basis of a departmental proceeding.
Dismissal on the basis of the conviction.
Conviction.
My was convicted. That's why I'm saying. The facts no more exist now as he has been acquitted all the charges. Therefore, the natural consequences would be his reinstatement in service. We therefore uphold the finding of learned single judge and expect and dismiss the appeal. This is one. Next, 2015, 2 SCC, page 365, paragraph 26. Paragraph 26. We have answered the alternative legal contention urged on behalf of the appellant.
Paragraph.
Paragraph
Just a minute.
26, 26. We have answered, kindly see paragraph 26. We have answered the alternative legal contention urged on behalf of the appellant by accepting the judgment and order by the session judge, in which case they have been acquitted honorably from the charges which are more or less similar to charges leveled against the appellant in the disciplinary proceeding by applying the decision of this court referred to supra. Therefore, we have to set aside the order of dismissal passed against the appellant by accepting the alternative legal plea as urged and therefore having regard to the facts and circumstances of the case. Now here, my lord, disciplinary proceeding was also on the basis of the same charges. As in the convict, kindly see 1 second, my lord. Paragraph 12.
2000.
2003
Paragraph.
SCC 580, para 12. Para 12.
Yes.
The fact that the appellant was involved in a criminal case is not disputed by the appellant. What is contended by him that he was ultimately acquitted by the Court of Chief Judicial Magistrate Agra, and therefore involvement of the appellant in a criminal case could not have been made the basis for terminating the service. Since the appellant was acquitted and it was a clean acquittal, stigma attached to him of having been prosecuted in a criminal case could have been treated to have been disappeared, and no argument can be allowed to be raised for justifying the order of dismissal on the ground of appellant's involvement in a criminal case. This is, I think, absolutely covered the judgment. Yes. Yes. Now, we have already shown these are the judgments. Now, kindly see page 29 of the petition. See page 29 of the impugn order. Dismissal. Page 29.
Just give me a minute.
Yes.
Page 29.
20,
Yes.
17th of May 2018. Just is a small two paragraph, pages, whereas so and so is
Just yes.
my lord, whereas so the petitioner, then CDPO, Deputy Director in charge, were arrested on 35/2009 in connection with Bosista PS case number so and so, on the ground that Mr. Khan has allegedly entered into criminal conspiracy with some other person, and in pursuance of the criminal conspiracy, he, by abusing his official power position as fraudulently and dishonestly, misappropriate government funds amounting to so and so from various development scheme of agriculture department so and so, thereby causing huge government wrongful loss to the government at tune of rupees so and so. Whereas Mr. Khan was subsequently convicted in Niyai case by Honorable Niyai Special Court, Guwahati, has found him guilty under section 120B so and sentenced him to imprisonment of 10 years with fine of so and so years imprisonment. Whereas the Superintendent of Police, Niyai, by
Okay.
letter,
This is
request-
under the 311(2)
Yes.
and Rule
because,
10.
yes, because of my conviction.
Conviction.
Wait a minute. Now, this was put to challenge before this honorable court.
Mm.
And that time, our plea before the court was that this order has been passed by the lending authority. Borrowing authority is the district council. So we sought one judgment of this court. They have to consult, the lending authority has to consult the borrowing authority.
Mm.
On this ground, I have been told, and there is an order I have seen, there was an interim order saying this order. But today the position is different. The today position we will not bring into it, because we don't want to bring that whether lending authority, borrowing authority. It is now this impugn order as case 29 is based on conviction, and my termination of 311(2) is only on that ground. So today the position of the law is very clear. Once you have been acquitted, either you reinstate or position as it is at that relevant time. If I was placed under suspension, then a departmental proceeding will be initiated again. Now, at one point of time, my lord, when the charges were leveled, departmental proceeding, we came to the court. We came to the court and there was an order. Kindly see that order. It starts from page
51.
48. 48 was the focus notice which was to us.
51 is the
And
order.
51 was the order, and the last portion of it, page 54. Kindly see last few lines, the last paragraph. It is no doubt true. State can conduct two simultaneous proceedings against a delinquent through a criminal proceeding. However, the normal rule is that
During pendency of that will remain state.
this is what I am not saying. What I would have said, reinstate where I was. I think this is a fit case. Your lordship can take a judicial notice on that,
But
on
not,
my judgment.
but no judgment before vacation. Yes.
I'll be very brief. Well, I'll argue on merit. But propriety demands
My
that
lord,
judgment should have been brought on record, either by filing a small.
Your lordship, but just
Okay, we may, we have heard at some length, but
maybe some queries. I don't know.
no,
I'll
queries,
maybe know.
queries is another issue. Other part is that I also think that you should bring the judgment by way of an affidavit.
No, we'll bring it. It's no
It's
problem.
no difficulty. Only, I think
No,
the
no, absolutely no problem.
second,
We'll bring it.
That
I-
they
no,
ought to have
no,
done it,
No, what
is
I-
not it, Mr. Das?
well, I will definitely bring it. I'll advise
then this
that. I will no
issue,
doubt about it. Then I will ask my learned friend to bring an additional affidavit.
That is important.
I thought that it is a judicial order passed by this.
No, understand, but it relates
Let it
to,
be, let
that
it
should be in, on record of the proceeding.
My lord, I assure before the court that my learned friend will file an affidavit, bringing notice to the court of it.
At least something to show that's because whole writ petition is on a different
Now,
setup earlier.
on a different
Now,
footing.
altogether different. Now, due to subsequent event, okay, we'll not go in the technicalities in a writ petition. Now a new thing has happened in the middle. So at least bring on record that this is the judgment. Therefore, now no more whatever you have argued.
And not that I'm raising it today. Last occasion I pointed out that today you are relying on the judgment. Second,
No,
I'm not.
we
I'm
know
not
that.
against the council, man. I'm not against the council. Secondly, my lord, there's one more point. Possibly
That
maybe
after going through it, I also think so because uh, we'll have to determine.
refer to the
We will
paragraph.
have to determine whether after acquittal, what will be your status. Your whole case was that I cannot be proceeded till the determination of the appeal. So in a sense, this has become infraction. Appeal is over. We are expanding the horizon of this writ petition.
Exact.
Isn't it?
It is.
If yes, then what are you doing all these days? How
No,
much cost?
I possibly might not, with great respect, I bit of differ
Yes.
with your lordship because it doesn't become an infraction.
No, it
Wait,
may not be
wait.
infraction.
But because your lordship is not that we have to file a separate writ petition
No, it's
stating that.
no, that's
So
why
what
we
I-
will
what
not
I-
go to all this.
Yes,
The caveat was
technically.
that we will not go to all these technicalities.
My lord,
Therefore, we are taking up
possibly,
this matter.
possibly your lordship has to look into the judgment.
Of
And
course.
their judgment has to be looked into it. The last paragraph I read, it all set aside the judgment.
No,
Conviction is-
even suppose it is honorable acquittal or not honorable acquittal, we will not endeavor it. What is subject to what Mr. Mojumdar said. Why should we go into that? If he has been acquitted, you are at liberty to proceed against him if you think so, if permissible under law. You proceed.
That's why from the very beginning I said,
You
your-
proceed.
I didn't say
You
my
have
lord-
your own satisfaction. Why should we give our satisfaction? Then matter ends there.
Yeah.
If we say it's an honorable acquittal, everything gone. If you want to endeavor us, we can endeavor. If we say this was an honorable acquittal and the charges are on the basis of same footing, the next writ petition will come that this is after these findings, you cannot even proceed in the departmental proceeding.
My submission is a step behind that. If I ask this, if I call upon this honorable court to determine
Mm.
as to whether there was honorable acquittal or not, then of course your lordship is as it saying, I run a risk if once your lordship holds it is honorable, everything moves.
Mm.
I am not on that one. My submission is, since I'll point out some paragraphs, since my submission is that the judgment itself says it is not honorable.
Okay, agree that this
Accept-
is not honorable. Assuming suppose you
Assuming,
accept your
yeah.
argument,
So
that this is not honorable, then what?
based on that, my submission is now the department should be left to take a decision in view of this judgment. This much only. I'm not saying that the lordship will determine whether it's honorable or acquittal. My submission, I'm saying that in view of this paragraph,
Of course, that is also Mr. Das, they will have to apply their mind.
That's
That
what I-
this is the situation.
I'm
Now,
not
in
saying
view
that
of
the lordship
that-
will decide
Hmm.
that it is, whether it is honorable acquittal or not. This is not the stage and this is not the case also in my own.
Not case.
As your lordship has pointed out, this whole case is premised on a different.
Mr. Das,
your
can we
lordship-
direct for a
no.
reinstatement?
No, I didn't say my lord.
Ah.
My lord will kindly see.
Hmm.
Hear me. I didn't say reinstate. What my learned friend is saying. No comment should be made by this book. Let it go. What I've understood. Let it go before the government. Government takes the decision on the basis of the judgment that has been rendered. This is what my learned friend is saying. But my lord has to let the government take a decision. My submission, my lord, with great respect to be recorded. These are the judgment that has been passed by the FXO. Let my learned friend also. Then your lordship will pass an appropriate order. Because I am not saying that to reinstate it.
No, suppose we allow your writ petition.
Yes.
According to you, what order you are expecting?
No, what I am saying that your lordship will record my submission.
Hmm.
Your lordship feels that it is a case where it is go before department.
No, I give you a liberty.
Yes.
What kind of an order in this writ petition is
order
being
should be-
accepted
Number
by?
one,
Hmm.
this order should be set aside.
The-
The order of termination should be set aside.
Hmm.
This is what I want.
Okay, so you want that order should be terminated because he has an
Whether it is honorable that your lordship will look
okay,
into it.
honorable.
But I am saying that this order should be set aside.
Hmm.
Let it go to the government.
With a liberty to them to so that they can
Proceed in
eventually
accordance
dismissing in
proceed
view
in
of the
accordance with the law, but this order should go. That's my submission.
that order of dismissal.
Dismissal order should.
I-
There's already a stay order passed by this court, but ultimately now the situation is different.
Okay, we understand. Now we can go. Yes.
Second, thing.
Hmm.
My lord, it's a writ petition. Earlier, this was not the issue before the Honorable Court. This was not a subject matter of this writ petition. Now that, in fact, in my humble submission, even at the time of filing the writ petition, since the NIA investigation, NIA, sorry, conviction in the NIA case has become a subject matter of this writ petition now after the acquittal. I am told that there is an appeal filed by NIA before the Honorable Court. Assuming that there is a stay, I don't know. I've got no information. I've got no control over it. If there is a stay, what will happen, man? By now, what has happened, I don't know. For that, I'm saying that NIA should have been party here. At least after they are relying on, after the acquittal, if they are relying on the judgment, NIA should be before Lord to say what is the position. Have they accepted it or have they prepared an appeal? I am told that there is already an appeal. In
No,
the appeal,
for the time being, suppose if that is your argument, for the time being,
Right.
before us there is an order of acquittal.
yes,
So suppose you reinstate him today,
my lord.
assuming for a
Right.
moment. Tomorrow the Honorable Apex Court convicts you. Again you will dismiss him. As simple
Well,
as that.
only,
So should we wait?
No.
No, since dismissal should continue till Supreme Court decides. That cannot be an argument.
I,
You
I,
can have an argument, yes, let them apply their own mind to the judgment and pass an order. That okay, fine, subject to what we think. But what will remain, giving it to them? That can be another question. When there is an acquittal, even if
If there is no-
honorable, not honorable, if when there is an acquittal, your dismissal was on the service was on the basis of an conviction, that is no more. So the natural corollary is reinstatement, subject to a condition that you can apply your own mind to
Take
the
it.
given facts,
take it.
proceed as per law.
My lord, let us put this way. Now today, before your lordship, there is a judgment of this court.
Hmm.
My termination simply is based on conviction. Now, as on date,
Conviction
now,
is no more.
tomorrow let us say the Supreme Court says the order of it.
Hmm.
What will be? I will be again back that again that has been, so your services will say that. So my services doesn't, it will say how it will be affected by this particular
Okay, let
order.
us hear Mr. Mojumdar. These are the overall ideas.
Only just before your lordship that
No, what I'm saying is judgment will not be possible before that.
no, we have.
Is your lordship directing them to
I want
I'll bring it.
that should be on
I agree.
record and or at least 1-2 statements
No,
so that we can have it.
Now, what we bring will be entire judgment. I
That's-
was not there.
No,
in the-
I'm not saying that part, but at least you will have to make a statement or note that this judgment has been passed. In view of this judgment, I am entitled for it. Where is that
No, no.
statement? Is it not required?
Sorry, I thought that it is a judicial order.
No, no,
by the
understand,
court.
understand.
I was
They
only
are
It
not
is
taking-
not a-
take notice for
No,
judicial.
no, we can take notice of, but this is not a judgment which you are relying on for the purpose of reference. This is a judgment of fact
by the
that
that is what
this
that,
person has
I mean,
been
this
acquitted.
is what I was saying. If your lordship is referring to it for the purpose of deciding any point of law, your lordship can always take it to judicial notice because it's a decision of the court. But
Suppose
when they are relying on a
I will quote, suppose in the
factual aspect.
judgment. I was thinking while reading through it. Suppose I will quote some paragraph of the
Ah.
judgment, how you were acquitted.
because factual aspect
That
is
should be on record
No, I
according to.
will put on record. There is
Ah.
absolutely no problem.
Okay, we'll hear
But
Mr. Modu. You in the meantime, you bring on record.
today,
I just-
today, I can conclude my part. I'll be wait for.
Okay, you conclude. Let us.
Let him con-
You can.
I'll
You
take
can.
you here.
conclude.
Right.
If he is here, I'll have to.
That is why I just
Yes, Majumdar.
I'll be very brief.
Hmm.
From the judgment in the appeal,
Hmm.
where he was acquitted, my lord.
Hmm.
I'm just referring to 3 paragraphs. para 14 of the judgment,
Okay. Para 14.
para 14 contains the charge sheet. I will not read that much, that's not necessary.
Okay.
His name is there.
Hmm.
And para 15 contains the charges framed by the NIA court.
Hmm.
And his name is there at serial number 4. In this background, what was ultimately, they were convicted by the trial court and appeal. Paragraph 197, they have read, my lord, from where the discussion starts.
Hmm.
I
Page 197.
one
Paragraph.
paragraph. In fact, his name is mentioned in 197 only.
Just a minute. Take mark, please.
The two technical submissions, let my submissions may kindly be recorded.
Hmm.
One, my lord, that NIA should have been made a party here.
Hmm.
Second, CPI
First
also
part, Mr. Mujumdar, while countering that argument, submit that the present writ petition is cannot be maintained in absence of NIA,
and also the CPI
NIA and CBI
in view of the
being made a party in view of
Hmm.
the fact that original investigation was carried out by CBI, hereafter by NIA, and charge sheet was also filed by NIA, and the NIA has preferred SLP against the judgment dated 2022 on the basis of which the petitioner claiming their instead.
so far as the appeal filed by the NIA that is only my
Knowledge.
knowledge. I have got no
That is
official
knowledge. That knowledge is in a public domain.
Yes, that's what I
Yes.
so you may kindly
Okay, we'll,
not
we'll
mention that I have got questions of document. I've heard because NIA knows I'm not representing the NIA nor the CPI. Secondly, my lord, now that the prayer is for reinstatement on the ground that he has been acquitted, the writ petition should have been amended.
uh, in absence of the any amendment made to the writ petition,
Specifically, the prayer
specifically the prayer portion, the present no writ can be issued directing the respondent to reinstate the petitioner on the basis of his equity.
in this diagram.
Now
Para-
page 197.
Melody, para 193.
Para
It will be page 193 for the para 190.
Hmm.
I will not read all this. I'll read only the relevant tab. Para 200 minute I'll read. My
Para 200.
para 2. My learned friend has read, but then area or the lines on which I'll be relying possibly were not.
That is the contention. That paragraph is important for you and him all,
Yes,
is not it?
I'll be relying on only 3 to 4 tabs.
Yes.
There are 200 cases. We are of the view that a minute analysis and discussion of these findings is not required in this case because the prosecution did not propose any charges for criminal misappropriation, criminal breach of trust, cheating, fraud, and forgery against any of these accused appellants. It cannot be denied that the allegations reproduced herein above would unquestionably give rise to the above offense. This sentence is very important. Here, my lord, there were basically 2 allegations. I'll say allegations. I'm not referring either to the criminal proceeding about misconduct or to the criminal offense. But the allegations were that there was a misappropriation of funds, number 1, and then
That fund is siphoned to the extremist
Yes.
DH. This court in appellate says when DH is not is a criminal organization and therefore
there is organization, not there is no material.
no material,
So
therefore will not even go to the second.
Yes.
second. This is what I have
No, so
read in between. I have got
so
that.
far as second part is concerned,
Hmm.
my lord, the contention of the other side was that this part of the investigation was handed over to the CBI. Now, this honorable court in appeal has said there is no record about the status of that. So the allegations about fund, etc., remain. It's open. I'll only point out that.
Yes.
So this second sentence is very important. It says that it cannot be denied that the allegations reproduced herein above would unquestionably give rise to the above offenses. So offense is there. Second part. As has been mentioned above, the prosecution and the trial court took hands off this important aspect of the case by a lackadaisical observation that investigation into these offenses had been handed over to CBI. However, it is an admitted fact that not a single document pertaining to the registration of the case by the CBI or the conclusions charge sheet, if any, presented in the court concerned against the accused appellant was brought on record by the present case. Then, my lord, the next paragraph, few lines. The major task of prosecution allegation in this case, in this regard, is that the officials of NCHA Council, so and so, facilitated the illegal transfer of funds to the farms of the accused appellants, Jayant Kumar Ghosh, Devash Bhattaji, etc., by fraud and forgery, and thereby the funds meant for the development activities of the NC Council were siphoned off and were routed to the members of the DHTJ for funding its terrorist activities. All these financial irregularities, fraud, and misappropriation were done under the directions of the accused. All accused have been acquitted by the trial court by the charge under section 18 of the UPA Act, which is the substantive offense of conspiracy under the UAP Act. Now, this is important. The acquittal from this substantive offense was recorded on the premise that the accused persons were being convicted for a broader offense of conspiracy, punishable under section 120B IPC. However, what is relevant to note here is that the conviction for the offense under section 120B IPC simpliciter has been done without recording specific findings that the accused conspired with each other and committed the offenses of fraud, forgery, and misappropriation under the IPC and the criminal misconduct as defined under the Prevention of Corruption Act, so that the funds defalcated by these illegal means could be siphoned off to finance the terrorist activities of so-and-so. The accused so-and-so have been convicted for the offense under section 17 of the UPA Act on the investigation that the funds of the council were illegally routed to them for being provided to the members of DHTJ for financing its terrorist activities. It is thus obvious that guilt of the two public servants, so-and-so and so-and-so, and the contractor, so-and-so, has not been recorded for the actual substantive offenses they allegedly committed, but by branding them to be in conspiracy with the members of so-and-so. They were straight off convicted for the offense under section 17 of the UPA Act without holding them guilty of the substantive offense which they allegedly committed for siphoning of the funds from the NC Hills Council. Thus, before evaluating the prosecution case against the accused, issue which is required to be assessed beforehand is whether the prosecution has been fairly able to prove beyond doubt that the DHTJ was a terrorist gang indulged in terrorist activities which were to be funded by the illegally siphoned of money with the aid and assistance of these 5 appellants. Now, my lord, one part. My lord, the paragraph 203, I will not read fully. Last and bottom, my lord, the bottom line, starting from the prosecution has not.
However, it may be
My lord, the last line of the 203 paragraph.
203.
My lord, of
The
prosecution.
prosecution.
The prosecution has not given, Lord Smith got my lord. Lord Smith got my prosecution has not given any details about the CBI cases registered in relation to these very allegations of defalcation, fraud, forgery, and criminal misconduct by public servants, as noted at the paragraph 378 of the impugned judgment. Thus, before appreciating and adjudicating upon the role assigned to these 5 accused, we would first like to adjudicate the broader issue whether the prosecution has been able to prove that DHTJ was a terrorist gang involved in any kind of terror. So there are 2 parts. Misconduct is there, but this court, while dealing with a criminal appeal, ought not to have and should not have and has not gone into that aspect. Now, there are 205. Now we proceed to discuss and appreciate The evidence of the witnesses connected with the Executive Council of NC Hills and ex-cadres of DHT, DHDJ, it may be stated here that almost all the witnesses from these categories did not support the prosecution case and turned hostile. The trial court discussed the evidence of 8 witnesses, namely Spencer and Mallard. I skip the names. Thereafter, the sentence starting with the word all these witnesses. All these witnesses did not support the prosecution case and were declared hostile. This I'm pointing out for the purpose of relying on those judgments where it has been stated that witnesses turned hostile and then a acquittal comes. What happens? Now, just one more paragraph. Para 230. And 230. That apart, the investigating agency very conveniently walked its hand off the most important facet of the case, that is, misappropriation of government funds, criminal misconduct, and forgery, etc., by claiming that request was made to the central government to get these allegations investigated into either by the CBI after seeking necessary consent from the state of Assam or by the ACP of the Assam Police. Chief Investigating Officer C. Swenso stated that CBI has made investigation into these allegations. Thus, the incriminating findings recorded by the trial court on these very allegations virtually encroaches into the territory of the proceedings contemplated upon the result of investigation filed by the CBI, SC, if any. The exact status of the state investigations was not brought on record of the present case, which is yet another loophole in the prosecution case. The findings recorded by the trial court holding that these allegations stated proof without framing formal charges lead to a situation of grave anomaly. The probability of these findings having an adverse prejudicial effect on the right to fair trial of the accused who may have been charged by the CBI to SCP on these very allegations cannot be ruled out. In this background, my lord, this paragraph 232 comes, where I'm reading only the third sentence onward. However, we make it clear that the findings recorded in the judgment shall not prejudice the other criminal cases, if any, registered against any of the accused in relation to the allegations of defalcation of government funds, criminal misconduct, fraud, forgery. So, on the basis of these paragraphs, my lord, my submission will be that it was purely a technical ground on which he has got it. It is not a case where evidence was.
The Mojumdar order contains that in view of the determination made and relied and the determination made and relied by him necessarily shows that the petitioner has not been honorably acquitted. Rather, the allegations regarding misappropriation, fraud, etc., has been left open for the other investigating authorities, if so advised, to left to the other way if initiated. And the acquittal was only on the premises that the prosecution has failed to establish that DHT within bracket J is a terrorist organization. That being the position, the learned appellate court has not entered into the other aspect of the matter and the charges framed against.
And primarily,
Therefore, it cannot be said that it is an clear and honorable acquittal. That being the position, the employer is within its right to apply its own mind to the determination made by the court while acquitting
and take it,
acquitting the petitioner
and take it.
and take a decision.
My lord,
In support of such contention, Mr. Mojumdar relies on the decision of the Honorable Apex Court in
one more submission that most of the witnesses turned.
It is a further contention that admittedly the acquittal, one of the main reason for acquittal was that most of the witnesses became hostile. And in that background, it cannot be said that it was an honorable acquittal and not on the ground of beyond reasonable failure to prove the case beyond reasonable.
The first judgment on which I am placing reliance is 2013, volume 1, SSC, page 519. I gave it. Parties names are my Deputy Inspector General of
I've
Police,
got it. Paragraph.
paragraph 24. May I read it?
Yes.
The meaning of the expression honorable acquittal came up for consideration before this court in RBI versus Gopal Singh Panchal. In that case, this court has considered the impact of Regulation 46 for dealing with the honorable acquittal by a criminal court on the disciplinary proceedings. In that context, this court held that a mere acquittal does not entitle an employee to reinstatement in service. The acquittal, it was held, has to be honorable. The expression honorable acquittal, acquitted of blame, fully exonerated, are unknown to the Code of Criminal Procedure or the Penal Code, which are coined by judicial pronouncements. It is difficult to define precisely what is meant by the expression honorably acquitted. When the accused is acquitted after full consideration of prosecution evidence and that the prosecution had miserably failed to prove the charges leveled against the accused, it can possibly state that the accused was honorably acquitted. In R.P. Kapoor versus Union of India, it was held that even in the case of acquittal, departmental proceedings may follow where acquittal is other than acquittal. In State of Assam versus Raghava Rajagopalacharya, this court quoted with approval the views expressed by Lord Williams in so. The expression, we can keep this, we can straightway go to paragraph 26, because this has been mentioned in the paragraph 24. As we have already indicated, in the absence of any provision in the service rules for reinstatement, if an employee is honorably acquitted by a criminal code, no right is conferred on the employee to claim any benefit, including reinstatement. The reason is that the standard of proof required for holding a person guilty by a criminal code and the inquiry conducted by way of disciplinary proceeding is entirely different. In a criminal case, the onus of establishing the guilt of the accused is on the prosecution, and if it fails to establish the guilt beyond reasonable doubt, the accused is assumed to be innocent. It is settled law that the strict burden of proof required to establish guilt in a criminal court is not required in a disciplinary proceeding, and preponderance of probabilities is sufficient. There may be cases where a person is acquitted for technical reasons, or the prosecution giving up other witnesses since few of the other witnesses turned hostile, etc. In the case on hand, the prosecution did not take steps to examine many of the crucial witnesses on the ground that the complainant and his wife turned hostile. The court therefore acquitted the accused, giving the benefit of doubt. We are not prepared to say that in the instant case the respondent was honorably acquitted by the criminal court, and even if it is so, he is not entitled to claim reinstatement since the service rules do not provide so. My one more submission will be, in the service rules, there is nothing that after you are acquitted, there will be straightway reinstatement.
No, anything on that you, because under Rule 10 or something like that, where there is a provision that you can be dismissed from service without departmental proceeding.
Well,
without departmental proceeding on the basis of a conviction.
Therefore, I'm not
now, what is the rule provide in case of an acquittal?
The rule is silent.
Rule is silent. And in this case, we do not know the fact. In this case, there are two parallel proceedings. One is of a departmental proceeding where, and other is of a criminal. The person was dismissed on the basis. Person was dismissed on the basis of the departmental proceeding.
In
this case, and this was challenged before a single judge. Single judge says since he has been acquitted in criminal proceedings, so therefore there is a difference of facts in so far relating to the present case.
To that extent, there is a
difference. No.
Next paragraph I'm reading.
So in this context, that departmental proceeding parameters or standard of proof in departmental proceeding and acquittal is different.
Different.
And the principle of law settled that two proceedings can run simultaneously.
Simultaneously.
And therefore, only on the ground that he has been acquitted, it will not necessarily lead to a conclusion that he can also be dismissal self will be bad even if it is after departmental proceeding.
True, ma'am.
But suppose in a case when whole basis of dismissal is on a criminal conviction, then what will happen?
Ma'am.
Whether that principle of honorable acquittal will be applicable.
That is what you talked about.
That will have to decide.
But on the next paragraph, I'm reading.
Yes.
That paragraph is also some relevance.
Hmm.
We have also come across cases where the service rules provide
Hmm.
that on registration of a criminal case, an employee can be kept under suspension and on acquittal by the criminal court, he be reinstated. In such cases, the reinstatement is automatic. That's what I'm saying. Here, it will not be automatic because the rules are silent on.
Hmm.
There may be cases where the service rules provide that in spite of domestic inquiry, if the criminal court acquits an employee honorably, he could be reinstated. In other words, the issue whether an employee has to be reinstated in service or not depends upon the question whether the service rules contain any such provision for reinstatement and not as a matter of right.
Hmm.
It's my time. Next is 2019, volume 10 is 367.
Just a minute. Yes,
Para 13 lot mein hai.
this is 2019
2019
10 SCC.
10 is Karnataka Power Transmission Corporation.
Paragraph?
Para 13 mein. One paragraph only, more or less on the same lines. Lot is got para 13.
Yes.
Having considered the submissions made on behalf of the appellant and respondent number 1, we are of the view that interference with the order of dismissal by the High Court was unwarranted. It is settled law that the acquittal by a criminal court does not preclude a departmental inquiry against the delinquent officer. The disciplinary authority is not bound by the judgment of the criminal court if the evidence that is produced in the departmental inquiry is different from that produced during the criminal trial. The object of the departmental inquiry is to find out whether the delinquent is guilty of misconduct under the conduct rules for the purpose of determining whether he should be continued in service.
No quarrel on that.
Madam.
You can proceed. No quarrel.
The next one is 2005, volume 7 SSC, page 764,
Paragraph.
para 11. Malar, para 11, somewhat,
There is also no quarrel.
somewhat in the middle, in a criminal trial,
Hmm.
incriminating statement made by the accused in certain circumstances or before certain officers is totally inadmissible in evidence. Such strict rules of evidence and procedure.
No quarrel.
Malar.
Two different standards.
Well.
You have always at liberty to have parallel. No quarrel.
Now, this will be of
So basic question here is
Well.
whether when a dismissal is on the basis of a conviction,
well, I have understood.
when
is
the
the-
conviction is converted into acquittal,
Acquittal, what will happen?
what will happen?
This judgment may be of some importance. This 1997 4 is the
Hmm.
page 385,
Paragraph.
para 5. Marriage. Small judgment. Para 5. It is true that the respondent was acquitted by the criminal court, but acquittal does not automatically give him the right to be reinstated into service. It would still be open to the competent authority to take the decision whether the delinquent government servant can be taken into service or disciplinary action should be taken under the CCS CCA route or under the temporary service route. Admittedly, the respondent had been working as a temporary government servant before he was kept under suspension. The termination order indicated the factum that he, by then, was under suspension. It is only a way of describing him as being under suspension when the order came to be passed, but that doesn't constitute any stigma. Mere acquittal of government employee does not automatically entitle the government servant to reinstatement. As stated earlier, it will be open to the appropriate competent authority to take a decision whether the inquiry into the conduct is required to be done before directing restatement or appropriate action to be taken as per law, if otherwise evident. For this matter, I am saying that now the lordship may, of course, record all these events. Now they should be given the opportunity to taking it. They will take a decision in view of all this, and the wrong is always there. That may be.
Okay, third in part. List for further hearing on
After
after. Ready to go. In the meantime, the respondent, the petitioner has submitted a copy of the judgment passed in criminal appeal number 238/2017 and the connected appeals, on the basis of which the petitioners are basing their case. Therefore, let the said copy be brought on record by your hand.
But-
by the next day.
like
That is, of course. After before before.
18th is after
Have it before. Let us have the Bihu feast with this
11th.
11.
But
You bring it.
Yes.
Yes, Mr. Bhattacharya. So, Razi, you can argue as you wish, the way you like. Either bench. Huh? Okay, we are going for final disposal or what? As you wish, as whatever you say.
Could be for final,
Today?
not today because they have not filed any appeal. Last 4 years.
Yes, yes. Who is for that?
health department.
Yes, where is help? Call them. What is the issue, Mr. Razi here?
Medical college. Professor has been,
Dismissed.
he has been dismissed subsequent.
Uh.
Before that, his legal practice has been taken. Now
His
today,
license has been taken away to practice. Any interim order?
yes, it's okay. So what I said,
So by 7/9/2018, your license of practice are issued. That is, there is a stay.
it is
We'll admit it. And stay will continue.
no,
Or if
But
you
I-
want that, we should decide at the earliest.
no.
You
No.
need an affidavit. Yes, yes. Call the health. Name soon.
Let
Health,
me
health,
let me
health.
point out.
Yes.
Last 5 years, no affidavit is filed on the matter. All over the country, it is said. It's the date. That is why I say the earlier position about is to rule. And then here the
That is what I was thinking. If interim order is there, it will be until further order.
5 years I'm out of job. I'm a lecturer.
So therefore, yes, Mr. Gogoi, no affidavit for last 5 years.
But the penalty part is already over, but my lord, I will file my affidavit on a short point whether any notice was served to the petitioner before, my lord.
But 5 years, Mr.
Um,
Bhattacharya is sitting from the morning.
My lord,
No, no, my lord, I take a very strong view.
Hmm.
Court should come very heavily. It's a question of belief. Secondly, all the time we are blamed.
Not only whole system is being blamed that court cases are not being taken up 2015.
Even
Mr.
yesterday, newspaper also regarding bail and the Supreme Court has
immediately on the opening on 5th.
You
No,
filed
my
the
lord.
affidavit before that.
what I say, let it be admitted, let the hearing be fixed, and then, my lord, within that,
Otherwise, it can be, my lord, disposed of at the admission stage. sir,
But it
instead
has
of-
not been. So, since Mr. Okay, okay. Admit, Mr. Bhattacharya, assisted by Mr. Bhattacharya. Also heard Mr. Bhattacharya. Admit this, admit this petition, issue rule, call for the records returnable on,
My lord, in February, in that case, sir, in between,
returnable on
let it be on a hearing. Sir.
let it
6th
be
of, 6th of February.
Oh, yes,
a
6th of
date of
February.
it.
6th
Of
of
date of hearing, 6th of February,
Published.
6th of February,
Before that, I will fact check.
6th of February. In the meantime, the respondent health department may file their affidavit, and if no affidavit is filed, this court will proceed on the basis of material available on record. The record pertaining to the punishment inflicted upon the petitioner be kept ready on the next day,
Let me make 13th of February.
13th of February.
Right.
Interim order passed earlier shall continue until further, till disposal of the.
My lord, this is not the health department. The entire issue is relates to, my lord, Assam Council of Medical Registry. They are the one who has reported.
Who is the,
I am appearing.
you are appearing? Okay, yes, respondent number
It will be respondent number, my lord,
Four.
4 and 5.
4 and. Okay, we'll decide on that.
Lot.
What is this?
Disability pension lot.
Huh?
Disability pension lot.
Disability.
Lot. And there, army, they have cited one judgment where the army pension rule will be applicable to them. We
Mm.
said, Lordship, that CCS rule will follow.
Mm.
Lordship had asked us to make an research whether both the Lordship, I pray for some more time in this. Sir, we
What
have
does just remind me? So many cases, everything has gone.
statement of
Okay, we vote the rules.
both the rules.
Uh-huh.
Lordship, my friend has made it, Lordship, but I request some time, Lordship, to
Okay, so give us a copy also.
These are only provisions of
provisions,
the,
my friend.
okay.
Because today morning I have just checked out, there are some case laws, Lordship, I have to go through. Here, not here, the only.
What is the case fact? Just tell us the fact. You are,
petitioner-
yeah?
the petitioner,
Mm.
he
Enrolled as
appointed it in 1991.
Mm.
Then discharged on 31st March 2001.
where is the discharge?
On the ground of disability.
They discharged at not paid 25. As per the discharge certificate, Lordship, at page 25, that's it, Lordship. Page 25.
When we have fixed the discharge method, that left you as army, pension. Service to CCS. What was her name? Not RTP. Other side was This was there. That Mr. A.K. Dutta was there. Yes, Mr. Bora, you were here. You were sitting behind. That case. Pension was refused, psychological treatment. Assam Rifle. Huh? Disability. Yesterday's item number. We'll take up both this matter on next day. You are here, that is why we want your assistance. Bora was arguing for the petitioner. S. Bora. What was her name? S. Bora and A.K. Dutta. List along with that petition. I think before vacation, huh? Before vacation. No, these people are in distress. We want to determine. Huh? Item number 23. Okay, I'll pass a order here. Mr. You see, what is the principle of granting a disability pension? This is one. Other aspect is that more or less law is well settled.
My friend has made this.
More or less, subject to what you argue, it is settled that if there is no detection at the entry point,
That
at entry point, and it is detected during the service,
then it
presumption is that it
Attributed-
occurred during attributed to the service. This is, if that be so, in other case I have seen, because nobody could assist us.
Assist.
Absolutely no assistance yesterday. But specific entry that on that date of he was having no disease, even he subsequently cured, and his level of disease also not that serious. This is all this finding. Subsequently, one liner, it is not attributable. What is the basis? No basis.
because they, in this case, medical board has conducted. Medical board has
Any findings that
No,
it was, he
there
was
is no
having,
opinion regarding that point.
because there are certain questions.
Yeah.
Whether you are having this, any earlier disease, everything was negative, and suddenly they came to a conclusion. 2-3 judgments are there.
Okay.
So we want your assistance. Forget about the decision adversary litigation. Because yesterday we did not have any kind of assistance. Mr. Bora was, we even thought of engaging him as an amicus, but then we thought two petitioners are fighting, why they should feel bad also. That I have collected already, because nowadays we will have to do our homework, judges' job. What you say, Mr. Dhar? Tomorrow. This matter is tomorrow. We may not conclude it, but we'll just deliberate on this. Please, this matter tomorrow, along with WPC 3001 22. None appears for the petitioner on call. List after 6 weeks. Yes, Mr. Dhar.
Yes. Whether the it put the post of agriculture administrator. Then my lord, the year 1906, an advertisement was issued my lord for filling up that particular post. I applied my lord with all my credentials. Thereafter, my lord, thing was communicated to me. In the year 2017, my lord, I came to learn that in my post, the respondent number 5 was appointed in my name. Thereafter, my lord, I submitted an application for RTI, taking some documents from them, but they have furnished me the document that I had annexed with my application form. That also is signed Annexure 8,
Is
Annexure 8.1 at page 34. It is the copy of the reply submitted to me.
you are what is your name?
I am Madan Mohan Nath.
They have appointed some other modern Mohan.
My lord, their case is that respondent number 5 is an imposter.
Okay, who is representation for?
Respondent number 5, we have to file an affidavit.
Hiding the Okolata, he came once to me. Thereafter, he never contacted. There is
Then
no
he-
contact. There is nothing, Lord.
We will give an investigation by CPI.
My lord, by direct, anything, my lord.
That cannot be.
And
We
in
have
You
fact,
file an
my lord,
affidavit.
in their affidavit, my lord, they have admitted this fact. They have submitted a report, my lord.
My,
Their
Well,
affidavit filed on
no, my lord, our inquiry proves that, my lord, the respondent number documents are all correct. And he's
they
continuing.
have furnished me my document.
My lord, he is claiming that that is his document.
Okay,
But my lord,
Let him
We-
find his affidavit.
my lord,
okay.
we have nothing.
You file affidavit.
Lordship, I'm not in a position. Lordship. In fact, Lordship, I am submitting.
No connection.
No connect.
No Kalatnam.
No.
Okay.
Okolata was filed.
Filed?
He came once, Lordship. Thereafter, no.
So we'll asking him to personally present.
Lordship, Lordship.
My lord, by direct.
Okay.
My lord will direct the director
To communicate this order.
communicate this order to him, and my lord will
Then
take
he'll
it.
come to you directly.
My lord, may I point out one thing?
Hmm.
My lord, in their affidavit, my lord, filed by the government director, my lord, not government director, on 3/2/2022, they lordship kindly come to page number 11. This is a report, part of a report submitted by the Deputy Director of Agriculture.
Page
Page 11 of that affidavit, my lord.
you ought to have filed an FIR.
I have
No,
already
he
filed an
filed
FIR, my lord.
FIR,
He was arrested, my lord.
arrested, he came back.
He was placed under suspension, my lord. Therefore, I came before this honorable court. This honorable court, while pleased to issue notice in the matter, was further pleased to direct the respondent not to fill up that post. But, my lord, from the report, in the last paragraph, my lord, they have reinstated that person, my lord, where there is an order from this honorable court not to fill up that post, my lord. So this is the mala fide, my lord.
My lord, not to fill up the post, he is in
They
service.
have, they have not
He is
even
service,
bothered to
he
take
is service, my lord,
leave from
for
this
so many
honorable
years.
court, my lord, for filling up this post.
My lord, he,
They have contempt, my lord,
my
on
lord,
their
he
part,
came
my
in
lord.
2019.
They may laugh, my lord.
Just a minute, just a minute, just a minute.
That conclusion, my lord. Page 11. And on earlier occasion, dust notices were issued, my lord. He refused to accept it, my lord. I don't know why.
What happened to the criminal case?
That, my lord, that instruction I have taken.
You have that.
Yes, sir.
You have that. You file an affidavit. What happened?
Yes.
If it is, there must be an investigation which
Yes,
we
yes.
cannot do. But
Yes.
we'll have to direct, since you have already filed an affidavit in a exercise of jurisdiction, we can very well ask the officers or the department to,
My lord will direct some authority, police or,
no, we'll do it, but not
will be-
in absence of him.
my,
Let him be here.
my lord, my direct. Even CID can do, my lord.
Yes, yes.
We have no issue, my lord, in that.
Okay. The present writ petition is filed with an allegation that though the petitioner, namely Madan Mohan Nath, was duly selected for the post of
Sericulture demonstrator.
sericulture demonstrator after a due selection process. However, in his place, the respondent number 5 was appointed in as much as the respondent number 5 has impersonated him to be the present petitioner. Accordingly, an FIR was also lodged. FIR was also lodged. Full stop. Notices were issued to the respondent number
5.
5. Respondent number 5. Mr. Upadhyay, learned counsel submits that though he was instructed to appear by the respondent number 6, however, no
Five, sir.
Huh?
Five.
persona 5. Wakalatnama was given.
That was given, Lordship.
You
He-
file also.
I filed.
Instructed and accordingly he filed wakalatnama. However, after filing of the wakalatnama, the petitioner has never come and has not filed the affidavit. Where is the huh? 5, persona 5. Where is the dusty refusal of dusty?
My lord,
My lord, he has already appeared to Dusty and
Okay, no, that he will say record his conduct also for giving
oh, my lord.
the satisfaction of his personality.
I'm sorry, my lord, there is no affidavit from our side, my lord.
Okay, then okay, full stop. The presence of the respondent in the given fact, respondent number 6,
Five.
Respondent 5, in the given facts of the present case, in the considered opinion of this court is necessary. Accordingly, let a notice be issued to the respondent number 5 through the
Director Sericulture.
Director of Sericulture, asking the respondent number 5 to remain personally present on given date. Remain personally present on given date. January. At least 4 weeks time. 30th of January 2024 at 10:15 a.m. before this court. Full stop. Necessary steps be taken by the petitioner through the registry for that purpose, and copy of such notice be served upon Mr. N. Dhar, learned R. Dhar, N. Upadhyay and R. Dhar I have mixed up. R. Dhar, learned standing counsel for the Sericulture Department, for forwarding the same to the Director Sericulture. Full stop. On after service of such notice, the Director Sericulture shall file an affidavit to that effect. That notice has to that effect. List accordingly.
Deeply obliged.
You do the needful for all these copies and steps and all.
My lord, will take register step.
No, through him. It's the,
My lord,
no, through Mr.
yes, to director.
Through Director. So everything you will have to do. He will not do.
My
And
lord,
give it to him, hand it over,
will do.
and he will then send it. Okay, and we'll order her that you will also file a affidavit that you have duly served it upon
Yes.
Mr. Thor.
I'm deeply obliged.
Item 10, it may be taken up after vacation, but
Item.
10.
Yeah.
This is item 10. What is this?
So the appeal and revision has been discussed. Till hearing is Aditya is appearing in this case, he has to left the court.
2019 matter. On the prayer of the learned CGC, the matter stands adjourned and be listed in the second week of January.
Correct, sir.
No, sometime today. What is the issue?
That was the state qualified.
Okay. Get qualified. Why is this before this?
Yes. Rejected Arkansas only because the date of birth is first step. But
they have
No, tell us, this matter pertains to bench two. Isn't it?
Yes.
Then why this is listed here? So Mohanto, why this matter, this is bench two?
He has not, that is I is not taking because just.
Okay, okay. Okay, 412 order, okay. What is the issue here?
Issue here, my lord, the petitioner before your lordship, my lord, he is my lord debt qualified.
Hmm.
And his my lord case was, she my lord, sorry, she is debt qualified. And her case was not considered for my lord post of discharge.
Hmm.
Because my lord, there is a overwriting in his.
Her.
Her document, my lord. There is overwriting her age. So that's why, my lord, I earlier opposed this honorable court. And this honorable court passed an order that is Annexure 9, page 21. Sorry, 27. That order was sent back to the authority, my lord, considered and passed the dispose of the representation. And accordingly, a representation was disposed of with a speaking order. That speaking order is sent before this honorable court.
There is a overwriting.
My lord,
There was an overwriting.
no, my lord, your lordship.
Where is the record?
My lord, I am appearing for Board of Secretary Education. Last occasion, my lord, honorable court directed us to verify this Annexure 6 of the writ petition. Duplicate certificate,
Annexure 6,
page 20,
page,
page 24.
Page 20.
yes.
My lord, that document has been verified in the board's office, my lord, and it has been found to be tallied with.
It should be 21, 27, 12, 75.
Yes, my lord. Tallied with.
No, I have submitted, my lord, I have submitted duplicate copy to the authority, my lord, before the government, my lord. But they say that I have not submitted. But in the speaking order, that by way of additional affidavit, I have, my lord, with the duplicate copy. So, my lord,
Who is for the education?
one hand they say there is
Yes.
overwriting, other hand they say that there is no duplicate copy. But in fact, I to send at the same time,
Yes, where is your affidavit?
I have not filed it.
Yes, tell us. So what to do? This matter is pending to now. How you have rejected her candidature on the basis. Now how will you compensate her? Select poster filled up. Now how will you compensate them? What to do, Mr. Any scope? Suppose we
Some posts are lying vacant, my lord. They can, my lord, they can consider my case.
against the selection process is over.
The selection, no, my lord. That selection I have already qualified. Thereafter,
No, what I could understand is you are TET qualified.
My lord.
But while filing an application for specific under an advertisement,
My lord.
when scrutiny was made, they rejected your candidature on the ground that there is overwriting.
My lord.
So, there is no stay order keeping any vacancy. So that selection process is over.
My lord. Yes, rightly you have the point.
So
My
now
lord, there is one
suppose
scope.
what is the scope of this writ?
My lord, that I have to, my lord, taking that.
That we can say that was wrong and giving you liberty to file a civil suit for compensation.
Yes, my lord. Exactly, my lord.
Can we direct that no, give her an appointment in a different selection process?
That cannot
be
be done. I'm not paying for that also. Because it definitely again
certain cases at the right time it should be there.
Yes.
There ought to have been a stay order.
for today only, my lord, I am taking it. I don't
No, understand. So
yes,
today you are being engaged on the apprehension that it may be dismissed
all right,
or
my
being in flux was That's why your presence is required.
So every year it is happen. My lord, it is every year, my lord, there, but
We can give a thing that this was a wrong, but we cannot go proceed. He can have his, on the basis of this wrong, he can get subject to what affidavit they file. Yes. There are two aspects. What is correction, corrected copy, or what is overwriting. Even if you overwrite in a Xerox copy, they have right, if they have rejected, they have rightly rejected.
correct.
Your date may be correct. There is
But
no
correct.
difficulty.
But they say that I have to, that is not the ground, my lord. Your lordship,
You say that
they
they,
said that they have not submitted
Yes,
duplicate
yes,
copy.
when-
I have
when-
submitted duplicate copy.
when
After vacation.
give a date.
There are two vacancies. Which one?
Fourth of
But we are giving you till 4th. If no affidavit, the person will be here. Either affidavit or the person. Director, who has passed this order?
Speaking order, my lord.
Sarva Shiksha. So mission director will be here.
For the Sarva there are another
So let there another person be here. Who is that another person?
test.
Huh?
Yes.
This is the difficulty when you take up a matter of difference when standing counsels are not here. We cannot blame them also.
Yeah, exactly, my lord. Because
Because they are
there is
specific bench.
specific is there.
That's why they have sent her.
Anyway, my lord.
Okay, the learned counsel for the SSA press for inform your SSA counsel. Press for and is granted 2 weeks time to file affidavit. I do not think anything, sir.
Yes. Except combined.
You have the
I can-
instruction. Except company or
Yes, yes.
you can
Because next year I have to again apply.
apply. You'll have to apply. Now this time you give the not proper copy. You have had an experience
My lord.
being casual.
Definitely. My lord.
Yes.
Keep your-
Yes, Mr. Doctor.
My lord, Doctor, may kindly have a look at the order, my lord, passed by this court, my lord, on 230920.
230920.
That is
Mr. Sutia, we're awaiting for you.
Simple table.
Yes.
Petitioner
That's
actually,
why we awaited.
yes,
On
petitioner actually age is 60 years something. Is it correct? As per our record. Subsequently, what happened? A petitioner approached Seba, some honest plus officer is there. He issued in a 14 years. That is confused to the department. So ultimately, we have clarified that 14 years is erroneously oversaid due to 14 years. It is not correct. So a correct age is 60. Simple thing. Available we have filed.
yes, my lord. But he is saying, my lord, that affidavit is correct. What may take up this affidavit?
Yes.
His affidavit.
let us first understand what is
What is the, that's why, my lord.
what is your grievance?
my
Yes.
lord,
Which
my lord,
order?
Lordship, may kindly see the order dated 230920, passed by this.
Okay.
Everything has
Okay. Where is your that certificate?
my lord, Lordship will start to affidavit.
Page 15?
Yes.
Where do we get that?
My lord,
14 years, 5 months, 19 days.
Yes.
This, according to you, this is correct.
yeah. Now next page, my lord,
Hmm.
the birth certificate. roll number so and so, aged 14 years, 5 months, 9.
Okay, fine. Then
My lord, now, my lord, during the pendency of this case, my lord,
Mm.
they have issued.
no. This why your employer has not believed this?
I have asked them to.
Because according to you,
My lord.
they have recorded your date of birth in a different way.
Yes.
So you said that this is my certificate, correct it.
And what they have done, my lord, like Dr. kindly see, 14 years, 5 months, 19 days.
Hmm.
They have put on, my lord, 14 years, 5 months, my lord, 1960. 14/05/1960. According to the survey.
14 years, 5 months,
19 days.
19 days, okay.
The person who has written in the service book, my lord,
14 years, for 5 years, 19 days. Okay, where is the service book?
service book is not. He has written, my lord, date of birth 14/05/1960.
Where do you get that?
That is the wrong, my lord. That is the wrong, my lord. That is
Page
page 13.
page 30.
Page 30.
Page 30.
Page 30, my lord, the last page of my petition. It says, my lord, the superannuation is fallen due on 30/09/2020.
Page 30.
30. Annexure 13.1. One.
Okay.
So I had challenged this, my lord.
Hmm.
While, my lord, this case was pending, my lord, my learned friend had filed an affidavit, my lord. In that affidavit, I have filed a reply, my lord. In the
Where is that affidavit?
my lord, your lordship, before taking the affidavit, my lord, lordship will kindly take my affidavit in reply, my lord,
Hmm.
at that is, my lord, filed on 04/12/20.
I have got it.
Lordship got it, my lord.
Hmm.
There, my lord, page number 6, my lord. Page number 6, my lord.
Issued by the Seva.
Yes. Okay. Here it out.
Hmm.
Number 1, the letter by so and so are genuine and issued from this office. Number 2, the actual date of
Page 6.
page 6. ma'am.
That is from the Board of Secondary Education
Yes,
to the
ma'am.
Director of Health Services, Assam.
Yes, ma'am.
Subject verification.
Yes, ma'am.
Therefore, I am to direct you that the documents photostat of the candidates which have been sent for verification, comma, HS is found as shown below against the name.
Yes.
Comma. Okay.
Second paragraph is important, my lord. The actual date of birth of so and so bearing roll number so and so is
What is
16
that?
years 05 months 19 days as on 1/3/1977.
No, I'm not getting anything. Page 6, Annexure 1.
Annexure 1, Annexure A.
A.
That affidavit.
Affidavit is reply. This is affidavit in reply.
That letter is from Shobhan Kasari to Director of Health Service.
Just a minute. Affidavit file reply by, okay. I was in different affidavit. Page 6.
Page
Okay.
6, ma'am. Annexure A.
Okay.
From Kasari to Director, my lord. Lordship found it, my lord. With reference to your letter said above, I am directed to inform you the details of the clarification as requested by you with respect to the verification report of so and so, the petitioner bearing so and so, are mentioned below. Number 1, the letter by so and so are genuine and issued by this office. That 2 letters, my lord, they state, my lord, my original date of birth is the actual one. Second paragraph. The actual date of birth of so and so bearing roll number so and so, HSLC item 1977 is 16 years, 5 months, 19 days as on 1/3/97 as per record, madam. In the letter white number so and so was typed as 14 years, 05 months, 19 days as on 1/3.
In place of
In place of 16 years,
5 months.
so and so as on 1/3, throw oversight. Oversight.
That is, my lord, second letter.
I have not completed.
Just a minute. 14 years, 5 months, 19 days as on 1977. But his certificate also says the same.
Yes, they have not disputed my admit card. Now my learned friend has filed an affidavit, madam,
That is more important.
Okay, coming back.
Yes, my
What I could understand is that your certificate, as per your certificate, you are 14 months and something.
yes, my 14
There
years
is-
old.
And they have not questioned the genuineness of those two certificates.
No.
Now they say, as per record, 16 years something, and it was written as oversight.
No, my yes, that's true, my lord. First they say,
Oversight in the subsequent letter, 2018
Yes.
letter.
first they
But
say,
what about the certificate?
certificate, my lord, I doubt it, my lord, regarding it. Doubt it, my lord. I doubt the record submitted by my learned friend.
No, no,
I
because,
will produce the original record. Yes, no, no, no. This the record you were
because
relying
Mr.
upon.
Mr. Sutia,
Yes.
you look into this. As per your letter, which you are relying on, it says the certificate is genuine.
We are not saying, my lord, like that. Yes, you have
Huh? You are saying that,
letter is genuine because
no, not letter. The certificates are genuine. But the letter issued is by oversight written as 14 instead of 16.
Yes.
But according to Mr. Dotto, where my certificate is 14 so and so, how can there be an oversight?
Yes, man. No, my
And
lord.
this is your case.
Yes, man. And he relied upon two documents, and at that time, I'll sum up quickly. Page 20, my lord, annexure 5. I beg to state my actual date of birth as per educational certificate and other records of age statement is 12/9. But in my service book, it is wrongly recorded as 14/5/1960 instead of 12/9/1962. So this is an application made to the authority, my lord. Then the authority requested the SEBA, my lord, to clarify the point. Then SEBA wrote a letter, my lord, that is at page 24, my lord. Page 24, Dr. got it, my lord. My lord, with reference to letter cited above, I am directed to inform you that the documents so and so of the candidate which you have sent for verification are verified and found as shown below against the name. My lord, here, my lord, 7th column, my lord, date and date of birth and age, my lord. Age on 1/3/1977, 16 years, 5 months, 19 days. So this letter was written on 31/10/2017, and it was given by my lord one BC Medhi, who happens to be the deputy secretary. Again, my lord, he page 27. my lord.
So this is according to you, there is no difficulty.
No, this is
This
difficult.
is the difficulty.
difficult. He stated, my lord, 2 years. My difference is 2 years, my lord. Now, again, that person, my lord, again wrote, my lord, that your lordship will find at page 26, my lord.
Is
26. my lord. Otherwise, same thing, my lord. Here's the column, my lord. Age 1/3/1977, 14 years, 5 months, 19 days. So, in the first letter, they have stated one thing. The second letter, this is to be correct. So, thereafter, my lord, the notice of superannuation has been issued. Then I approach this court. While approaching this court, my lord, while the case is pending, my lord, that annexure A, page 6 of my affidavit in reply.
Page
Page 6 of my affidavit in reply. Page 6, my lord, annexure A, my lord. Here, my lord, second paragraph, number 2, my lord. The actual date of birth of so and so, bearing roll number so and so, is 16 years, 5 months, 19 days, as on 1/3/1977, as per record. In the letter, byte number so and so was typed as 14 years, 5 months, 19 days.
54 is annexure
Page
26. Page
Eh,
26.
Yes, man. Yes. 26. Typed as 14 years, 5 months, 19 days, as on 1/3/19 in place of 16 years, 20.
No, we understand. Now they say this is incorrect. This was as per record.
Yes, man.
Now 5/4/2018, according to them, they have missed.
Oversight.
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 Now your certificate also tallies with the whatever you claim.
Yes, my lord. Now, my lord, while this case is pending, my lord, case was pending, my lord, my friend has filed an affidavit, my lord. That your lordship will see, my lord, the affidavit filed by the secretary, my lord.
Where is that?
My lord, it's there in the record, my lord.
By whom?
By
Rothindra Bhuya.
no, my lord, it's
no.
my lord.
Senapati,
Suranjana Senapati, my
Secretary Seva.
secretary. Sir.
Secretary Seva.
Respondent number 4, my lord.
Just a minute.
no,
Respondent number 2. Respondent number 4.
4.
Yes.
Yes, my lord, Lordship will see I Srimati Suranjana Senapati, my lord. Now, Lordship will directly turn to paragraph 3, my lord, next thing.
Oh.
Okay.
Now, paragraph 3, Lordship will see, my lord. The deponent begs to state that the petitioner has appeared in HSLC examination 1977, bearing roll number so and so, and as per statement of particulars of candidate submitted by the head of the institution at the time of appearing in the, my lord, this is very important, my lord. At the time of appearing in the state examination, date of birth of the petitioner was recorded as 16 years, 5 months, 19 days as on 1/7. So what we mean, my lord? So we all appeared, my lord, HSLC, my lord. So when we fill up the form for HSLC, the school used to send the record. So Mr. A, father's name is so and so, B's father. So my learned friend has this statement relied upon 2 documents that has been annexed. Now Lordship has turned to page 4, my lord, that tabulation register, my lord. Lordship will see that first, my lord, one Shibam Shyam Sundar Saha, that is below, my lord, Arun Chandra Saha. Is my
Yes,
father.
Shamsulak Barbhuya.
Yeah, my lord, no,
0346.
yes, my lord. Now why I'm referring to first one, my lord. Anyway, my lord. Now Lordship, third one, my lord. Somir Kumar Bonik, that is son of Shankar Bonik, my lord. Now Lordship will see, my lord, MPI 8020, fail, my lord. Fail, my lord. Below my name is there, Mohammad Samsul Haq Barbhuya. So and so, my lord, 87 B, P, meaning pass. So the secretary has filed this affidavit stating that the documents were supplied at the time of appearing in the examination. So how the secretary came to know who will pass and who will fail? So this is a document, my lord, it is prepared after I have passed the examination. My
Not before that, but
lord. How can it be? Lordship has seen, my lord.
Phase 3, man.
Fine, please go ahead. Please go ahead. Please go ahead.
After age की मान लिखा 16 years 5 months 19 days. Same. What is it?
Okay, then.
Now the previous page. Previous page also, my lord. My name appears in the second, my lord. Samsul Haq Barbhuya, Lordship has seen, my lord. Here they have put in my age as 16/5/19, my lord. Before my name, my lord, 0346, my lordship has seen, my lord. That is the roll number. How they came to know my roll number will be so and so. So all these sheets are prepared after I have passed my matriculation certificate.
Okay.
So now that paragraph 3 is a very wrong statement, my lord. It is a wrong statement, my lord. Incorrect statement filed by the secretary.
So according to you, this was your age was 16 years, 5 months, 19 days on the date of preparation of this tabulation
Yes, my lord.
and preparation of your tabulation,
No, preparation of my admit card, my
preparation of your admit card.
admit card. And these
In admit card, what is your age written?
admit card, lordship will not pay.
As per your admit card, what is your age?
14 years.
14 years.
Yes.
As per your admit card, it was 14 years.
14 years,
Now,
5 months, 9
what
days.
was sent by the school will click the everything.
Yes, but school has sent this after the result is over.
It is not possible.
Why not? That you have
Not
written that
possible.
to it.
Why he said, but
No,
why
no,
am
no,
I
no.
what does it-
Just a minute. Let us.
No. Why he is saying like that? After passing of the examination, particulars come. Who says? Who says? I appear SSL examination, Lordship appeared, he appeared. What does it mean? Before
No,
appearing in the
particulars comes when form is filled up.
examination,
Yes. And he put
when
signature
form
of
is
matter-
filled up.
Yes,
Therefore, what the form discloses.
yes,
Yes.
well,
Now, what is your stand regarding the
I will say.
okay, for the timing, let us keep it aside.
Fine.
Now, your certificate,
Yes.
prima facie shows that his age was
14 years,
14 years, 5 months, 19 days.
Right.
Now, we can understand that subsequent communication is a mistyping or what. But this is your certificate. Now, what will be the value of the certificate if
Yes,
we want
yes.
to go for this
I will come.
robbing and
my lord.
fishing
Yes,
inquiry?
Yes, now, my lord, section 90 of the evidence act.
Let him come.
Lordship,
Mm.
doctor, I think Lordship knows that
Mm.
95. 30 years old pilot seems to be a rate of pilot.
Now, here issue is this. A date of birth is generally entered on the basis of the
Statement of the
no. In the service book,
service.
date of birth is entered on the basis of the
Certificate.
school certificate.
School
Now,
pass certificate, SLC pass certificate.
SLC birth certificate or any certificate which
Yes.
is relevant.
If it is
With the
under
date
matric,
of birth is given.
Yes.
Now, his case, what if I could understand? His case was that, see, this is my certificate. In terms of that, my age is this, but you have wrongly entered my name as so and so. Fine.
Yes.
So he files a representation, please correct it. Now, department looks into it and says that we want a report from SEBA. Now, according to SEBA, certificate is genuine.
not I'm saying it's genuine. I'm not saying certificate about the certificate. We are only saying.
No, see this
No, not
affidavit, affidavit.
Yes, affidavit, paragraph 13, we say only as per record sheet, that is so and so, the age is so and so. We are not saying certificate, admit card is genuine. That's what I've come to. Lordship, allow me, I will submit it.
No. We
Briefly.
will come to you. We will come to you. No doubt about it. Don't
Yeah.
worry about
Our affidavit.
in this court that you will not be hurt. You will be hurt.
Yes, sir.
Just a minute.
Response number 4, my lord. Paragraph 2. Right, paragraph 2, Lordship.
Paragraph
2.
Dr. Ravi Rothindranath Priya.
No. Suranjana Senapati.
Suranjana Senapati.
Response number 4, affidavit.
Okay, just a minute. I was looking at something else. Give me a minute. What do you say about the certificate? What is your
Yes,
explanation?
that's why I am, first of all, my lord, kindly see writ petition page 15, it's admit card. In 1977, admit card is not only printed by, is not fill up the particulars by the SEBA. It is open blank and is sent to the officer in charge in the center, and they will fill up his name, father's name by hand. It is a type, I don't know. And they will fill up all these things. I appeared 1975. My admit card also like that. They to fill up by the school authority. And matching with the statement when sending for the SEBA for appearance with the HL7. Next to Lordship Policy certificate. This certificate issued in 1977. Lordship kindly see name. The all letters are cursive. All letters are cursive. Rule cursive. Number cursive. Age cursive. Years cursive. Months, days. Here he typed. There is no system at that time. All are cursive. All handwriting in certificate. I will produce it. Now I am submitting before Lordship. Let him produce the original admit card and this certificate. Then I will
No.
see. Yes.
No.
No, photocopy no. Original.
is the photocopy of the original.
Yes, because we'll take action, my lord. I informed the secretary now. They are searching it. I know well. I passed 75 SSLC. I know my certificate how to write it at that moment. There cannot be any typewriting. He write 14
What is the stand of the employer?
employer.
Why they doubted this? Yes.
They're appearing.
Where is the service book?
Totally false, my lord. It is. I will submit it. Service book.
Where is the original service book? With whom?
We have not.
Okay, Mr.
My submission to before lordship. These two documents he is to furnish before lordship the original one, so that I can verify.
Okay.
Original, not scan copy.
But
Verify.
one thing is to be, my lord, one thing is to be noted, my lord. This respondent number for affidavit. He stated, my lord, that the date of birth appeared on the basis of the statement given by the school authority.
Yes.
He
Paragraph
also-
2.
Correct.
Paragraph 2.
But these two documents, it shows that these were supplied after I have passed.
No.
No.
Yes.
It is given by the school authority.
Yes.
Suppose school authority gives you the form.
Yes.
On the basis of that, they have prepared subsequently
Statement.
when you pass. This is only statement.
That is
Yes,
called
ma'am.
MRS. Manuscript registered
See,
statement.
suppose this date of birth is given. Suppose this certificate, 14 years, 5 months, 19 days.
Yes.
This is issued on 27 June 1977.
Yes.
Certificate is issued on 27 June 1977.
Yes.
But they acquired the data when form is filled up.
Yes, exactly.
Isn't it?
It is not
Data-
tallied.
Yes,
Not
my
tallied.
lord. When they receive the data, my lord,
Mm.
data will come in this way, my lord. Name, father's name,
There will be a form fill up.
date of
How
birth,
college
date of
the,
birth and so on.
the school will forward it to the SEBA.
Yes.
SEBA will accordingly during tabulation they will enter
Yes.
enter their dates.
Yes.
So that date will have to correlate with the what is declared in the form itself.
Yes, my lord.
On the basis of
Yeah.
that, it is
Yes.
determined.
Now,
I will bring it.
now the question is
originally.
this, my lord, whether these two documents were supplied, my lord, at the time of filling up, after filling up the form, my lord,
No, kindly come to that page. Where is that page?
page 4, my lord,
Okay, page 4.
page 4.
Now see,
My lord.
what is this?
My lord.
What is this?
They say it's the tabulation rate.
So tabulation register.
Yes, my lord.
When
First is, my lord,
do you want to say
page
that 16/5/19, 16 years, 5 months, 19 days
yes. He recorded
could
it.
not have been entered on this date after declaration of at the tabulation.
Yes,
No.
my lord. My
No,
lord,
that cannot be because they are doing tabulation on the basis of the data already received
Yes.
prior to the examination.
Yes.
And then the earlier
Exactly.
one, my lord,
Which one?
the earlier page 3, my lord,
Page 3 is a
Ah.
thing, my lord, MRS.
MRS.
What is MRS?
MRS is manuscript registered statement. That
Ah.
statement is sent by the school.
School khana pa puthele, then
They are not make the party school.
then when the school sends it, my lord,
These are the
then
digits, my lord.
the board issues the admit card, my lord.
Hmm.
Already my roll number is already there, my lord.
Oh
No.
no.
This is a
Okay.
serial number.
Okay.
Now, how can it be serial number?
Yes, serial number.
Yeah, my eyesight is not so bad, my lord. It's written as my lord roll number, my lord.
Yes,
That's
roll
all.
number.
Roll number, my lord.
Roll number.
How can it be serial number? My lord?
No, roll number.
No. Suppose can it not happen?
Well.
I as a school in the month of March from at the time of fulfillment send it to the department. That is SEBA. SEBA will conduct an examination.
Yes.
So SEBA creates a roll number. Already they are having the data. What is your age on
Yes,
the
already.
on the date? Everything is there.
Yes.
Now what is this? MRS?
MRS manuscript registered statement
Manuscript register
Statement.
statement is prepared.
by school authority.
Uh-huh.
And they said it, we
When?
fetch it. Manuscript statement is come when before examination.
Yeah.
Before examination, they fill up the form, then they make a statement that 300 students.
So that on the basis of that,
We
they
recorded
have
their
registered
age.
your roll number. Subsequently, your roll number is created. This
Yes.
is only a data entry.
But below, my lord, the lordship will see, my lord, the date, my lord. The secretary has put a signature, my lord. 25/9/2020.
This certified
Well,
copy.
when they have
This is a
received,
certified copy, my lord. We original, we produce it. Let me produce the original one.
You produce the original.
Before that, lordship, direct them to produce this.
Okay, you produce your
Original.
original.
It is necessary, my lord.
If necessary, we'll send it to forensic.
Yeah, definitely produce. Definitely. And
let them also produce the record. my lord.
I will produce it, no problem. I know this is a fact, and this certificate is totally fact because this number cannot be
Okay,
typed.
okay, let us examine
Yes,
this
yes,
because it's a
exactly.
question.
And
You
my
you
lord,
have in them retired.
retired
Retired here, person.
during the pendency of the case. Sir.
Okay,
Part my lord. Lord.
Yes.
uh, during the parties are hard at line. During the course of hearing, a dispute as regard the genuineness of the certificate annexed to the writ petition as annexer
Uh,
1,
that-
annexer 2, and annexer 1 and 2,
One and two, my lord.
and annexer 2, that is
Epic right
the
certificate.
admit card
and the
And-
issued by purportedly issued by Secretary Board of Secondary Education Assam in favor of the petitioner and the certificate of passing high school leaving certificate examination.
But there is no signature, my lord.
Okay.
Maybe no.
Accordingly, the petitioner is directed to produce the original of the aforesaid two documents before this court on the next day fixed. Another dispute has been raised regarding the genuineness and validity of Annexer A and Annexer A series, that is MRS and tabulation register,
Yeah.
annexed to the affidavit filed by the
Respondent number 4.
respondent number 4. Accordingly, Mr. Chutia submits that he will produce the original record pertaining to pertaining to recording of date of birth of the present petitioner.
All party.
All parties.
Yes.
Accordingly, list this matter. When
Any date
give a date.
after latest,
After
my lord. January
25th of January 2020.
25th. Oh, yeah.
Can it be on my lord? 29, my lord.
29th of
Because
January.
the holiday one.
29.
29th of January 2020.
Let it be,
Obliged,
my
my
lord.
lord.
We have said it.
I'm obliged.
Heard in part.
That's the 9th of February.
My pleasure, Lord.
Hmm.
Lord, this matter pertains to recruitment of in the sub-inspector unarmed armed post. Basically, on the last occasion, Lordship has put a question regarding the ambit of judicial review in re-evaluating the answer, my lord. And in that connection, I have submitted two judgments before your Lordship.
Hmm.
And before going to the part of the judicial review, my lord, if your Lordship allows me, I would like to submit the facts first.
We'll hear it after that. These are not matters to be cited. As agreed to by the learned counsel for the parties, list this matter in the third week of January 2020.
The date may be
Give a date. You are for whom, Mr. Arunachal is in the entire east and
Yes.
then
yes, my lord. It covers more distance than the Manipur.
so if he gets that number, what will happen?
Not that
Hmm.
for a wrong answer.
Then
He gets the mark for a right.
then he gets the job.
Even if
What
my
is the
lord,
job?
sub-inspector, my lord,
Sub inspector of
unarmed branch.
Assam Police.
Yes.
Post are vacant.
Yes, one post was already kept vacant in the interim.
Otherwise,
No
expert
prejudice will be
opinion
caused
and
to them, my
the,
lord.
Government of Assam website, they say other.
What is the expert opinion? Who are the expert?
It is the more on the Manipuri is more on the eastern of Arunachal comes from somewhere in the north.
So, my lord, in the state,
We are not arguing on that.
No, we are not.
I'm just giving an overview of what.
So now the read court is to decide where is the Arunachal and what should be the mark.
my lord,
Okay.
even if
Okay,
the correct answer,
that day has also come. Anyway, we'll
even
decide.
if the correct answer is
If this-
given to
if-
me, then also I will be I will exit the cutoff mark, my lord, by removing the negative.
We understand that. We know your anxiety. You are, if for correct answer, if you are deprived, definitely will be here. And we'll have to see whether we can.
My lord, it's pending 2021, my lord.
No, that's correct.
More than 2.5 years, my lord. The other candidates
Okay,
are
let us
serving.
hear it. Chalo. Chalo. Why should you wait? Yes. Then pay cost is in urgency. Pay cost. Okay, not sufficient, not sufficient. Issue is limited. Okay, Argo.
Maybe on the third.
No. Argo. Argo, where is the advertisement?
My lord, advertisement at page 45. Sorry, 15, my lord.
Yes.
My lord, at page 18, my lord,
Page 18.
at the top, my lord.
At the top. The written
The
test.
written test will be of 100 marks and will be completely OMR based. There will be 100 questions and each question will be of 1 mark. There will be negative marking of half mark for each wrong answer. 1 mark will be given for the written test and half mark will be deducted for the wrong answer, my lord. In my case, my lord,
Now, which is the question?
question number 86, my lord.
Where do we get this?
My lord will get at page OMR sheet at page, my lord, 37. And my lord would get the question first at page 66.
Just a minute. Yes, 66 is the
66.
question.
Yes.
Yes.
Assam shares interstate boundary on eastern.
Question number?
Question number 86, my lord.
Question number is
The
Assam
top one, my lord. Assam shares interstate boundary on eastern side with Manipur, second, B. Arunachal Pradesh, C. Meghalaya, D. Tripura. my lord.
Okay, you have given
I have ticked Arunachal Pradesh. my lord.
okay.
And according to the key answer, my lord,
Answer key. Where is that answer key?
answer key is at page, my lord, 38, my lord.
Question number was
86, my lord, and the
Just a
answer is A.
86.
6, my lord.
86. Answer is A.
Yes, sir.
Okay.
That is
What was the answer in
that is Manipur.
the
my lord.
question is
According to the question chapter, it is Manipur. my lord.
okay. Now any scope for objection to this question? Anything?
Yes, my lord.
Where is that?
My lord will get the Assam map at page 71. my lord.
No. Assam map will go later on. Anything was given that any objection regarding question generally when OMR based is there, when answer key is provisionally issued and seeking objection anybody. There is no scope here.
No, my lord.
Only
was
this
no
is the
scope.
final
Yes.
answer. Okay. Now according to them, where is their expert opinion and university? Now what happened thereafter? You
Sir?
raised this issue.
No, my lord. I passed I have appeared in the written test and
No,
I
you-
have successfully appeared in the written test. Therefore, in the physical entrance test, I have also cleared that.
Mm.
In the subsequent, when the result came, my lord,
Mm.
then I came to know that my roll number was not there.
Mm.
Then I made an RTI application. Then came to know about this question answered and the key answer.
Okay.
Then I approached this honorable court.
Okay. What is their stand?
Their stand is basically
Who filed the affidavit? Who is the employer?
Dibrugarh University has filed respondent number 6 and 7, my lord.
Who said this question?
Dibrugarh University. my lord.
University. Where do you get that?
My lord.
Where do we get that it is the Dibrugarh University?
My lord, it's there. In my writ petition, my lord,
Hmm.
Was held by the typical university. Not in this.
there is no denial, my lord, by the respondent.
I suppose
Yes.
we hold that your question is correct.
Yes.
Now, there may be hundreds of persons whose answers are correct.
Maybe, my lord, but the result is over already, and the persons who have already qualified, they are serving in their job, and one more post is vacant already.
Suppose we say that you will have to suppose you hold that this is correct answer. If it is correct for if your answer is correct, it is correct for everyone.
And it would be wrong for those who have got the
Those
probably
who has given.
My lord, that I understand. My lord may even delete the answer also. Even my lord delete the answer, then removing my negative part.
No, understand.
everybody
Suppose we remove, it will be removed from everybody. Then whole selection will be
would have to be.
result will be different. Or
Yes,
do you
that will be fully unasked.
do you propose that no, this is a repetition only for me, so if I have come, give me not the other.
In terms of equity, my lord may enter in that by keeping aside all the other candidates.
That is against equity.
My lord, as
Equity cannot be individual based.
no prejudice will be caused to the other candidates and the respondents also, because already the selection has been over, my lord, and the one post has already been kept vacant. So in that case, I leave it to your lordship.
No, don't leave it to us. You will have to argue and so convince us whatsoever. You cannot leave it to that. I leave it to. Then your presence is not required. I'll pass order in the chamber reading your pleadings. Don't leave it to the judge. Judge knows nothing. You will have to convince the judge.
My lord, in that regard, already I have submitted one.
Our eyes are blackened.
Yes, I understand, madam.
We only see law.
I have submitted the Honorable Delhi High Court's Division Bench judgment, my lord, on the last occasion. If your lordship will look at that, may I submit the judgment, my lord,
Yes.
in regard to your lordship query.
Four 30. Yes, this is Delhi High Court.
My lord,
Delhi High Court.
yes, my lord. My lord, at para 81,
Para 81.
yes. We must harmonize, my lord, got it?
Hmm.
We must harmonize the requirement of the second condition with the requirement of not disturbing the candidates who have been declared as qualified, as also with the requirement of justice, fairness, and equity, insofar as the other candidates are concerned. We feel that this would be possible by re-evaluating the OMR answer sheet of all the general category candidates on the lines of summarized in the table set out above, by selecting the top 230 candidates in order of merit subject to minimum qualifying mark of 112.8, and by adding the names of the candidates, if any, who are earlier declared as qualified,
but do not find a place in the top 230 candidates after evaluation. My lord. In this manner, all persons who could legitimately claim to be in the top 230 would be included, and all those who were declared as having qualified would also retain their declared status. Although the final number of qualified candidates may exceed the figure of 230, this is the only way, according to us, to harmonize the rules with the competing claims of the candidates in a just and fair manner. A similar exercise would also have to be conducted in respect of each of the reserved categories. The entire exercise be completed by the respondents within a period of 2 weeks. Consequently, the main examination written would also have to be rescheduled and to keep enough time for preparation. We feel that it should not be
It
earlier
was a
than,
preliminary examination.
yes, my lord.
It
So
was a preliminary
to-
examination. There is a scope for objection.
to harmonize the situation for the just,
But
sorry.
there was a harmonization of situation was that main examination was not even held.
my lord,
See, suppose we pass this kind of order, this will even somebody may lose their job.
my lord.
Can we do that without hearing them?
In my humble submission, no. But my lord, since one post has already been taken,
Understand?
my
You
lord, my lord.
understand? Can we do when we found that there is a anomalies, or if we come to a conclusion, can we say, okay, forget about the others, give him? When there is an anomaly in selection, in fact, in case of a health department, we set aside the appointment of persons who were in service for 8-9 years. But we directed that it should be the whole select list should be recasted. And the petitioner did not get. Some other third party got the job. Again, the petitioner has come before this court.
But
But this is not a case where we should upset the entire selection.
But equally, my lord, the candidate also should not penalize, my lord.
309.
My lord is searching for Kanpur University judgment.
No, Kanpur University. Yes. Yes. Next. So Delhi High Court case is in a different context because examination was not over.
Yes.
So cut-off mark was sent, then written examination, viva was, everything was,
Well-
it was still not held. So Delhi High Court will not be applicable in the given facts of the present case. That order we cannot pass. All appointments will be upset without hearing the other parties. Yes. Now what is this?
Lord, one more judgment by the Honorable Supreme Court in 2018.
Hmm.
So
What it says?
this might not help me, but it will help your lordship,
To dismissing your petition.
my lord, in adjudicating this matter.
Okay, very good. We like counsels like this. Not like Mozumdar.
My lord, this matter has, this case has also referred to Kanpur University and the Ranvijay Singh case, my lord. Sorry. My lord, in from para 9, my lord.
Para 9.
Kanpur University versus Samir Gupta. This court was dealing with a case relating to the combined pre-medical test. Admittedly, the examination center himself had provided the key answers, and there were no committees to moderate or verify the correctness of the key answers provided by the examiner. This court upheld the view of the Allahabad High Court that the students had proved that 3 of the key answers were wrong. The following observations of the court are pertinent. We agree that the key answers should be assumed to be correct unless it is proved to be wrong, and that it should not be held to be wrong by an inferential process of reasoning or by a process of rationalization. It must be clearly demonstrated to be
Yes, what is your stand in the affidavit?
Our stand is that the question paper setter has given that lordship would find
Page
page 5 of my affidavit at para 10. I'm sorry, I'm sorry.
Paragraph 12.
That was the wrong exit. I was talking about running page 86 is my affidavit. And my lord, at page 85, para 13, para 12 and 13.
Para 12 and 13. That is what.
According to the setter of the above question, the correct answer for the question was option A, Manipur, and all the other options were to be set wrong. The petitioner has opted Arunachal Pradesh is the correct answer instead of Manipur. Therefore, the choice of petitioner was done. Then lordship will find at paragraph 13. With regard to context of paragraph 9 of the writ petition, the answering deponent says that according to the setter of the question, the geographical boundary and the name of states and countries surrounding the state of Assam are mentioned in the official website of the Assam government. As per the official website of the government of Assam, the states situated on the east side of Assam are Manipur and Nagaland. As Nagaland has been excluded from the 4 options, therefore Manipur is the correct option. Because it should kindly come to the writ petition for a moment. The lordship would have page 71 is the map.
Yes, 71.
71 is the map which is annexed by the writ petition.
71, yes.
And extra 12. Lordship will find the map of Assam towards the north. Lordship will find Bhutan and Arunachal Pradesh. Comes down a little bit on the northeastern side. Nagaland and Manipur are totally on the eastern. Now, Nagaland was not an option in the answer. So Manipur is there. Is what the question set up.
My lord.
Dictate.
My lord, what the question setter had stated.
This is a probable view as per Supreme Court judgment, so will not.
No, my lord, it is apparent from the list and from the next extract of Assam yearbook also, my lord. I have annexed it at page 73, my lord. Will get
See,
that.
Arunachal Pradesh is
And the
is
eastern side.
if we say is in the covering a portion of the eastern side and one portion in the northern side. Okay,
My lord,
one part is eastern, one part is northern, and Manipur in Nagaland in absolutely in the eastern side.
but my lord,
No,
from
no, listen to me,
yes,
eastern side. So therefore, they have opted for Manipur. This cannot be said to be a glaring mistake in as much as whole Arunachal is not in the eastern side. Whole of the Arunachal, suppose it would have been a Manipur, they say it is not in eastern, in northern, then it would have been a glaring. But in case of Arunachal, it is not glaring because majority of the portion is in the northern and one portion is in the eastern, no doubt about that.
so my
So therefore, the state which is absolutely in the stand, they have decided to give a right answer to that. Therefore, we will not, in an exercise of jurisdiction, replace their decision and understanding without that being a clearing illegal.
My lord, my humble submission would be that
Hmm.
in that regard, if there is any ambiguity
Hmm.
in the answers, suppose more than one answer is correct, because
We would have considered your argument had it been in
then
earlier stage, not
yes,
now.
my lord. If there is more than one answer is correct, or if there is any ambiguity in the answers, then lordship may remove the answers.
We can remove the sender. That will require a whole recasting of the entire selection. And in that case, some person may even go out from the selection process, which we cannot do without hearing them. And you have not invited them as a party.
But equally, in the case of that, my lord, if the answer is correct, the candidate will also should not penalize, my lord.
Should not be penalized.
My lord,
But-
my lord,
but-
my lord,
But in your writ petition, without hearing others, we cannot penalize others.
one more,
Because it is your responsibility to bring those affected persons.
my lord, one more submission.
Hmm.
In that case, my lord may give a direction to form an expert committee to evaluate these answers.
We are satisfied that they have not done any clearing illegality to exercise jurisdiction. Third, Mr. Swenshaw, learned counsel for the petitioner, also Mr. Mojumdar, appearing for respondent number
Episode 6 and 7.
6 and 7. Mr. Bora for
1, 2, 5.
1 to 5. Mr. Gogoi, are you there? The petitioner participated in the selection process for appointment to the 592 to the post of sub inspector within bracket unarmed bands in Assam Police pursuant to an advertisement dated 11/4/2018. Full stop. The petitioner scored 45.50 marks in the written examination and 36.59 marks in the what is PET?
Physical entrance test.
Physical entrance test and extracurricular activities, and 20 marks in the computer proficiency test. Thus, he scored 102.09 marks. Full stop. The cutoff mark for the OBC category candidates to which the petitioner belongs was fixed at 103 numbers. 103.
102.21. According to the affidavit filed by the respondent.
Okay, 102.21. 102.21. According to the petitioner, the answer to the question number 86 has wrongly been rejected. Answer to the question number 86 given by the petitioner has wrongly been rejected, and thus not only deprive the petitioner from a due mark, but also how many marks deducted?
0.5.
0.5 marks has been deducted from his total score. For giving a wrong answer. According to the question, the relevant question is quoted herein below. Assam says, here you see the Assam shares interstate boundary on the eastern side with A, B, C, D. Okay. According to the question setter and the answer key provided by the authorities slash employer, the correct answer of the aforesaid question is answer within bracket A. However, the petitioner has the petitioner has ticked answer number B as the correct answer. Full stop. According to the petitioner, from where we want to say that it is Arunachal in the north.
My lord, from the
According to the petitioner,
Assam Airport.
the
Map.
annexed map of Assam will clearly reveal that Arunachal Pradesh is situated in the eastern part of Assam, inasmuch as the which yearbook?
Assam Yearbook and Assam State Portal,
Assam Yearbook
2018.
published by 2018 published by
Editor Shantanu Kaushik Godwar.
publication house. Assam Yearbook published by a publishing house which is recognized as one of the
Edited by
edited is not important. It should be recognized. That how can we say that this is a correct yearbook? It's widely popular and accepted book. The Arunachal is situated in
And
the
also, my lord,
eastern part of the Assam. According to the petitioner, as per the Assam portal, where is that?
Assam State Portal at page 74. ma'am.
Page 74. Assam State Portal. Page 74. Assam State Portal. It is declared that the state of Assam is bordered by Bhutan and the state of Arunachal Pradesh in north, Nagaland, Arunachal Pradesh and Manipur to the east, Meghalaya, Tripura, Mizoram and Bangladesh to the south and West Bengal to the west. Therefore, there is a glaring illegality in treating the answer of the petitioner to be incorrect, and thus in the process the petitioner has been deprived from a valuable right of a public appointment. Full stop. Accordingly, he submits that a direction should be issued to accept the answer of the petitioner to the question number 86 to be correct and recast the mark in which situation he will be entitled for the appointment, inasmuch as he will score the required cut-off mark. Per contra, Mr. Mojumdar, learned counsel appearing for respondent number 6 and 7. 6 and 7 submits that the questions were set by Dibrugarh University and the question setter has treated the answer B, is that it? Answer A within bracket Manipur to be the correct answer. Inasmuch as the Arunachal, majority of part of the Arunachal is bordered in the north of Assam and a smaller portion of Arunachal Pradesh is in the eastern side, and majority part of the state of majority part in the eastern border is covered by state of Manipur and Nagaland. That being the position in Nagaland, and accordingly, as Nagaland was not an option, therefore the question setter has treated Manipur to be the correct answer, and therefore such decision of an expert authority should not be interfered by this court, inasmuch as such defect cannot be said to be a glaring defect. It is further contended by Mr. Mojumdar that if at this stage a direction is issued to correct the order, correct the answer, or to delete the answer, the entire selection process is to be recasted, and in that event, many of the already selected person may go out of the selection and go out of the selection, and those persons are not parties before this court, and therefore such exercise may not be taken in exercise of jurisdiction under Article 226 of the Constitution of India. We have given the excess considerations to the arguments advanced by the learned counsel for the parties. Peruse the material available on record. Peruse the material available on record. There is no dispute that Assam is there is no dispute that the state of Assam is bordered by Arunachal Pradesh in north, Nagaland, Arunachal Pradesh, and Manipur in the east. If we rely on the Annexure 12 map of Assam annexed to the writ petition, it is clearly shows that majority portion of the state of Arunachal Pradesh is situated in the northern boundary of Assam, and a small portion is covered in the eastern side, northeastern side, not even eastern.
My lord,
Eastern side, okay. You're happy.
in the eastern side, it covers more boundary than the Manipur.
No.
Yes, my lord.
No.
Yes. If your lordship have a look at the map, from
Stop. The majority portion of the eastern boundary, as discernible from the map annexed to the writ petition, is covered by state of Nagaland and state of Manipur. The option given was Manipur, Arunachal Pradesh, and Meghalaya and Tripura. Meghalaya and Tripura are not at all nearby the eastern side of Assam, eastern boundary of Assam, whereas Manipur is in the eastern boundary. Therefore, the decision of the question setter to treat the Manipur to be the correct answer out of Arunachal, Tripura, and Meghalaya, this court, in a considered opinion, in exercise of its judicial power, cannot replace such decision, more so when the same relates to a decision relating to a question and answer in an examination. Question and answer in examination. Full stop. The answer keys has been finalized by an authority, which authority by an university, and the question was said by any professor. Anything you have meant to a statement? No, that statement is not by an university. such committees, such decision of the university should not be interfered in exercise of a power of judicial review when it cannot be said that the answer is absolutely incorrect, or that it is an it is a glaring mistake apparent on the face of it, inasmuch as there may be some confusion regarding the actual situation of actual boundary, eastern boundary. But for the purpose of answering this question, when there is an option of Manipur and Arunachal in the eastern boundary, and considering the fact that majority portion in the eastern part is covered by Manipur and Nagaland is not an answer, such determination cannot be a subject matter of a judicial review in the given facts, and more particularly when it relates to an determination of correctness of an answer to a question. Accordingly, this court finds no merit in this writ petition. The same stands dismissed. Okay.
Most of it.
You will get it later on after vacation. File a certified copy so that you get the limit,
Most of it.
because you will get it online on the new year.
Highly pleased.
If you had allowed, then we would have done it immediately. Yes. Next case, yes.
Petitioner project
2000. Yes, where is S Bora? There is a direction to obtain some instruction. Huh? 1/4/2022. Obtain instruction total number of grade 3 posts in the office of district. Why this matter is listed here? Bench 2. No, bench 2. Why this is listed before this court? Huh? This matter pertains to bench 2. Accordingly, list it before appropriate. None appears. Yes. Yes, APTCL. None appears for the respondent APTCL on call.
I apologize.
Yes.
My lord, we still are waiting for the instructions. For some time.
But this is 2021.
Yes, my lord. My lord, I have the oral instructions, but I would want to put it on record.
So you file an affidavit
Yes,
in the
madam.
list of oral
Yes, ma'am.
because according to them it was an accident.
It
If
was
it is-
definitely an accident.
If it is an accident,
My lord, perhaps the dispute would be regarding whether the petition would be qualified for that.
where is the question of qualification in compassionate appointment?
My lord,
It's not a regular selection. You appoint her in a post where she is qualified.
I'll place it.
Yes, learned counsel for the FPT shall press for and is granted a last chance to file affidavit. This matter after 3 weeks.
I'm obliged.
See, if a person died in an accident out of his work, you have a policy. Do that. It cannot be a question that is not qualified. You are not asking her to be appointed as a managing director.
Yeah.
Is that it?
Yeah.
This matter is regarding appointment on compassionate term, my lord. In the year 2011, my lord, itself, Mr. Arora was, my lord, considered by the DLC. And subsequently, my lord, it was rejected, my lord, by the SLC.
When?
In the year 2017, my lord. To challenge it before this honorable court, my lord. And honorable court set aside the, my lord, said rejection order by the SLC and thereafter to direct it to place in the next SLC, my lord. But in the next SLC, that has not been, my lord, it's not confirmed, my lord, result has been found. And so far, other personal.
What happened in the next SLC? Rejected.
Your Lordship, that is what actually an reference for the health department would be able to clarify the question as to whether they were placed to put SLC or not.
To obtain instruction from in this regard.
Otherwise,
Whether it was placed on
Otherwise, Your Lordship, because the death was in 2009.
What to do? Court has directed for reconsideration. Cause of action is surviving. Can we say no, that judgment was wrong? Can we say? If we can, we prefer a bit.
2 persons, my lord, already appointed as along with us rejected. Subsequently,
Mr. Saliha, not Saliha. Upamai, learned standing counsel for the health department. Respondent number 1. Praise for and is granted 2 weeks time to obtain his instruction and file it. Please accordingly.
My lord, this employee, petitioner said, employees, master rule of they are regularized. That's the policy. After that, now they are brought back to original master Khalasi. So, my lord, page 33, they are
You
regular.
are for whom?
Lord, I am for PhD department.
Yes, what is you said?
Lordship, we'll have to seek some clarification because the regularization order that they are relying on that has been passed by the sewerage board, and Lordship, sewerage board is not the appointing authority, and
Who is the appointing authority?
the PhD is the authority.
Now, what is the series relation between the series board and the PhD?
They apparently, Lordship, they went for deputation to sewerage board. We are
Now
trying
you
to
send deputation master worker. Where is the question of deputation of master worker?
that is why, Lordship, there are some peculiarities. We are, Lordship,
Okay, file affidavit,
we'll file an affidavit. Lordship.
Actually, my lord, it is a bilateral arrangement. When they are master rule, they were sent. When they are born in Qatar, my lord, 5 years they served, after that brought back.
Now,
When they
do you want to say that though we are in deputation, person similarly situated in our parent department
Yes.
has already been
Yes,
regularized
yes,
because we are in the series board?
Yes.
How can you deprive? Is it your case?
Yes.
Yes, then
Article
suppose you send them on deputation, accepted. Okay. Now you sent on deputation. A is sent on deputation, B is not sent. The appointment on the same date, same nature, same everything same. Now you regularize B. And do not regularize A. And you say that no, now we cannot regularize. Will it be acceptable?
Lordship,
File an affidavit. This issue you'll have to answer this.
well, what had happened, the regulation was given by the chair, MD of board, without the concurrence of this PhD.
Yes.
So when there was a high court order, my lord, they were brought back to the department. So my lord, now it has been enlightened upon us that once you give regulation, you cannot take it back. But this board has been
Like these employees, Mr. Borua, those appointed in the service of the MLAs and ministers.
No, my lord, kindly page 33, kindly this board may come, has to come, my lord.
Okay.
Without this board, my lord.
File an affidavit. Board is a party.
Board is a party.
Who is representing board?
RM Das used to be there.
RM Das is difficult. You'll
Lordship,
have to give an invitation to him and we'll pass judicial order.
Lordship, there are two things actually we'll have to look into, Lordship. One is claiming regular.
Name is shown RM Das.
No.
Okay.
My lord, one thing I'll like to point out, my lord, page
No, no,
33.
Mr. Borua, if we cannot decide this matter, let
Yes.
us not waste time.
Yes.
Registry to list this matter showing name of Mr. RM Das, Learned Counsel for the Sewerage Board.
Yes.
What is the name?
Urban Water.
What is the short form?
AUW
AUW
SNSP.
AUWSB SSB AUWSSB. In the meantime, the Department of PHE may file their affidavit. List this matter after 3 weeks.
Last occasion, query was made whether deputation, type of deputation.
They will file affidavit.
Yes.
File.
That was
Which order?
order to got reflected.
Okay, then it's difficult.
Also,
you-
in this case, the prisoner was selected for the post.
No, have you filed the additional affidavit?
Yes, Lordship, already filed, Lordship.
Okay.
The additional affidavit, Lordship, subsequent development after filing of the report on record, Lordship. As per this, Lordship, after verification in the GMCH, which certified that the petitioner has disability of 13%.
Mm.
30%. She was sent to issuing authority. Issuing authority said that we cannot give any opinion and refer to the higher medical authority. Accordingly, petitioner was examined in the AIMS. AIMS has the certified, not certified justice, as per the medical report of AIMS. She has severe hearing impairment, and also advice for cochlear implant. It is a machinery that is implanted in the in case of severe hearing impairment. But the issuing authority again refused to accept the AIMS report and by order that the
Any interim order?
it was directed not to fill up the post by so by 22/8.
Why this matter is, this is education.
Education, Lordship.
Why this is listed here?
Health is also a part because it is the health department who has certified the
Okay.
and by 22/8.
Yes. Where is your authority?
Again refer to
Lordship, there are
medical
similar matters which were listed yesterday and today, Lordship, before court number 5, Lordship. There is an OM, Lordship. According to this OM, Lordship, we have asked them to re-verify or re-examine it.
To ask question. How can you, are you having a certificate issued by the competent
Yes,
authority?
yes, Lordship.
By,
Annexure A.
under the act?
Yes, Lordship. Annexure A.
How can you do this?
Similar
You are
matters.
above parliament.
Lordship, this we were asked by the Social Justice and Account Department.
Where is social justice?
Lordship, they have not made a party in this. Other matters.
No, there's no need of any act. You do on your own. Scrap this act. Rules. Yes, Mr. Gogoi. Where is your power? Tell us. Absolute without jurisdiction.
Considering the statute.
Yes, statute and rule. Then there will be nothing, no discipline will be there. You may have doubt upon them that they have issued wrong certificate. We have no problem on that. There is a provision of appeal, prefer an appeal.
In the statute.
You can have a, you can,
There's
up to
provision for
this
review
extent,
also.
huh?
There is a provision for review.
Okay, review, provision of review, but who will do that? There is a statutory authority created. Presumption is given that the certificate is the final authority. If anybody is grieved by such certificate, they can prefer review or appeal. Now, in every cases, you will have selection and you will have your own determination. The certificate you will ignore. Where is the question of ignoring a certificate? And scrap this act. If you want to propose, because this is a right created by an institute. And how the right will be created, how the right will be certified, a procedure has been given. A certificate is issued. We will have a presumption in favor of validity of that certificate. And nobody is saying this is fraud. Nobody is saying that this is not at all a certificate. You are saying no, we will not ignore them. We will have our own and we will decide. You cannot. You cannot. This memorandum.
Certifying authorities, my lord, they are, my lord, violating that.
We understand.
Apparently, my lord,
But
it has come out that
we
most of them
understand.
somehow they give the
We
40%
understand.
and-
So you do remove them. You are the state.
Yep.
If you get some you make some rule under the act to make them accountable, that in case event it is found, it will be removed, there will be penalty. But because of the some incident that they have done bad things, wrong certificate has been issued, can you override the provision of statute and rule?
More particularly when the signatures are genuine. By the
And you are not doubting their certificate.
here, my lord, Lordship will
You
definitely, my
assist
lord,
us.
Lordship will have to hear it, my lord. Otherwise, it will have a wider.
No,
image
sir,
cases,
that's
my lord,
that's
because
why we are
lots
not
of cases are coming up.
every day. That's why I was surprised. Even I passed certain stay orders.
Okay.
In fact, in one case, we have asked to continue with the appointment because already appointment was issued.
Yes.
And in this case, you do a test. Now see, you went to AIMS. AIMS overrules you will not accept. You are not accepting. AIMS is conformity with the certificate.
Yes.
Now we'll see. That makes Malafedi in exercise. Maybe you intentionally were rejecting these people to give us some favorable candidates appointment. Who
Yes,
knows
of course.
that you are blaming this person who are issuing certificate. The blame may go to you. You are taking advantage of this situation. Oh, forget about once you have rejected, court will not pass a stay order. Somebody will be appointed. His right will be created. What to do?
Lordship will post it after.
Will post.
Will
Will
also-
hear all this matter. I do not think this is having any sanctity under law. We'll just ignore it.
As of now, yes. And my lord, this particular
This is having no statutory weight. This is a piece of paper for us.
policy,
Policy decision cannot be on statute. The legislative policy is to give, and this is the procedure. Beyond that, this memorandum is having nothing.
this has been issued recent election.
Recently, but under what power? You say in pursuance of the right to show us the provision. Show us the provision under what authority you can do this. See this, you have given unto yourself some power which is not permissible under the.
But in medical, my lord, as far as the NEET exams are concerned, they are, my lord, in the prospectus.
That is
It has been given that
that is a different. This is a selection. She has been selected as a college professor. You may say that these parameters, because there are certain posts where Act itself says that these parameters in certain posts it cannot be appointed.
Right.
Fine, you say that. But you cannot say that no, we will not appoint you. Ignore the certificate by the statutory. You will have to argue this case, not Mr. Gogoi. Tell us what to do.
it posted after the vacation. Like probably, my lord, the AG has already been
See, in
informed
the
about
process, the
this.
students are also suffering. She is also it.
Yeah.
There is a stay.
And even though the candidates who have 10% disability assessed by the medical board, they were appointed. And Dr. N.
No, that is a different issue.
sir.
That we go. If they have done some illegal act, we cannot give a relief on that basis. That is a different
They
issue.
will not.
That we will not entertain. But you are for whom?
Let's find out if it is
What is your stand?
If the reviewing authority finds it that above 40%,
Where is the reviewing power of reviewing
so
authority?
that is the lordship. So
Review authority, you have given yourself a name, reviewing authority.
115 I have an extra for category.
When, tell us, we'll decide this at the earliest.
First week of January.
Huh?
First of
First week of January? Give a date.
Right?
9. Hard, 20, also hard. Okay, right. Affidavit file?
No.
Huh?
Higher education department.
Hard you can file.
I have.
And you?
Will file before.
Do you need any affidavit? They have asked you to go for review. You have reviewed it.
Yes, but otherwise,
It's a law point. Where is the affidavit is required? A vital question arises in this writ petition, which needs a determination. The petitioner is declared to be a person with disabilities by a competent authority under the
page 24.
under the page 24.
No, that's it. The rule 4.
Under what is the name of the act?
That's it. Rights of persons with disabilities.
Under the Right of Persons
With Disabilities Act 2016.
with Disabilities Act 2016.
Sure.
2016. And accordingly, she applied for appointment to a post earmarked for the candidates belonging to the person with disabilities. Full stop. Though the petitioner was selected, however, the employer has reviewed her disability status and rejected her candidate. Therefore, a question arises whether the employer shall have a further right to have a reassessment under the scheme of the Act 2016, wherein a detailed procedure has been laid down for issuance of certificate, and that too in absence of raising any doubt about the validity of such certificate. At this stage, Mr. Upamanyu, Learned Counsel for the petitioner, for the respondent Health Department, submits that he may be granted some time to address this court on the next date. Prayer is allowed. List on 11th of January 2020.
Apply.
That is regarding appointment on completion. The petitioner has filed affidavit reply. There minus there, but on my accessible copy.
When your predecessor in interest died, when the government servant expired,
Expired on 10 August 2007.
now thereafter what happened?
That
Manner 5 application. There is a DLC minus there.
When?
Page,
When the DLC minus?
page number 19.
No, tell us the date. 2013.
Yes, sir.
28/3/2013. Then what happened? DLC rejected or accepted?
Rejected.
Rejected. Then
In the year one.
no. Thereafter what happened? The DLC rejected. Then
And the DLC is not taken any decision regarding.
okay. Then
After that.
There is some development. I'm just fixing this latest SLC alert.
Yes, sir.
Their case has been considered.
after 2011, we'll now pass judgment that you should consider everybody's case. If you can consider it 2011, why should we reject 2016, 17?
My lord, this was considered because of some other. There are some orders, my lord, from this.
So forget about that judgment.
This judgment will override my. This is come in 23, my lord. I'm just trying to place the fact, my lord.
File an affidavit. Mr. Third submits that he has received instruction and will like to file an affidavit. Prayer is allowed.
Because of 1, 2
List of the
orders from this honorable court, my lord, government was compelled to, my lord, take some decisions.
File appeal.
We will file review, my lord.
Give the requisition. Yes. This 2020, yes. Yes, Mr. Third.
I will file a cover, my lord.
One affidavit has already filed, my required secretary.
Secretary file.
Secretary filed.
Secretary irrigation.
Irrigation. You are for
I am for SLC, my lord.
SLC. Mr. Third for SLC. SLC. Yes, no affidavit.
The instruction is still awaited, my lord. For some time.
2023. What is the issue?
Regular is not a minimum pay scale.
What is their stand? What is your policy?
My lord, actually they are trying to rely upon the judgment of Sanjeev Das, where it was said that if till the date of the judgment, these employees have completed more than 10 years, then they should be considered for minimum scale of pay, which is presently under consideration of the APDCL matter.
Okay.
Therefore, we require some time to put it.
This is the second round of litigation.
Yes.
The first round, this honorable court directed for consideration of regularization who come under Umadevi judgment and minimum pay scale to come under better. This judgment is
They
there.
are saying that this is under consideration. We'll wait for some time.
But they have passed an order which is impugned in this.
Well,
It
actually,
is at
what
page
happened was
46.
that initially when the
At page
petitioners
46.
came, those were limited in number. So we took a policy decision that we can afford to pay them at the minimum scale of pay. But then batches of writ petitions came to be filed. And thereafter we had to review our decision whether to go ahead and pay all the employees.
In the review of your decision, you have decided that we'll have a cutoff. Can you do that?
My
If
lord,
they are equally situated.
no, my lord, we have decided not to grant it to anyone as of now, because the financial implications would be huge if all the employees are to be paid. Because once
So you want them to work without being given the minimum pay scale in terms of ignoring the Supreme Court judgment.
my lord, that is the reason it is still under review. We are still going to take a decision as to whether we can accommodate all of them at a minimum scale of pay, because different
Do you
employees are
require
situated
them?
differently.
Do you require them? Are they working?
Yes, yes.
If they are working, if you require them, this is the mandate. You should be a model employee. Is a state corporation. You cannot say no, we will not give them. If your mandate of Supreme Court is there, you will have to. Forget about Upendas, forget about other schemes. Upendas may not be applicable. What is the judgment,
There
Jakit?
is specific direction of.
What was the judgment?
It is
What was the judgment? Supreme Court judgment?
No, this honorable court.
No, Supreme Court judgment.
Umadevi judgment for regularization. And this thing,
On the prayer of the learned counsel for the respondent, please this matter. After 3 weeks, on a date to be fixed by registry. In the meantime, the respondent appears shall make their stand clear regarding the consideration of the case of the petitioner in terms of the earlier decision of his court. Like
the second round of petition. The first round, my lord, there is a specific direction of by the honorable court to place the matter of the petitioner before the DLC.
we are repairing a forest.
No, Lord, PH.
PHE.
Yes, sir. We are waiting instruction on this, sir. Whether,
Let's see.
whether the application has been placed for DLC or not, just waiting for that instruction.
Okay. Mr. Gogoi, learned counsel for the learned standing counsel PHC.
PH.
appeals
120.
that he may be granted some time to obtain instruction of whether the case of the petitioner has been placed before the state S level
DLC.
district level committee in terms of this court's order dated 03/03/2021. Prayer is allowed. List after 3 weeks on a date to be fixed by registry. The Mr. Gogoi shall apprise this court on that. Yes, Mr. Goswami. That matter.
Yes. Appears the time is not much, but then the queue is also very short.
Will it be possible to dictate a judgment?
I believe it will not be possible, Lord, because he is always saying that my lord, my learned defense and my lord, all last instances, my lord, he is taking a view that this matter should be there. What is this?
No, not
Maybe
that.
this
But
court
take
is,
up the matter.
maybe the court.
There
there
will be
is
some
a problem, there is a
procedure.
different thing.
No,
my
no,
lord.
No. He is saying that he will argue a bit little length. So
That's what I mean, Lord.
that's why he's saying that may not be possible to deliver a judgment before vacation. He could understand that we are.
My elder brother will request some time.
As your Lord.
But we know Mr. Goswami is having
In a hurry.
hurry. Definitely will be
Every
hurry.
month. Your lordship, my lord,
Because we
already-
have on some little bit we have deliberated on earlier occasion.
yes.
You were not there on that day.
Not.
He was not there. Mr. Mohanto was there. So
my lord, for me, Lord senior advocate is more important because he
we
is
know that
representing
because
the institution
Mr.
and the record.
Mohanto is representing whom?
7, my lord, the private.
Okay, the person whom you have.
Who is the appointed Lord?
Why you have ignored him?
No,
According to him, he is in that kind of panel or list,
Yes,
something
yes.
like.
no,
Isn't-
not that
panel.
panel.
Huh?
That was the waiting
Top of the
list
panel.
of a different selection. And this is a different selection.
Okay, fine.
The earliest one,
Give a date. You are unlucky.
After vacation, then that is.
why after BU vacation?
No, there too will not go to the BOV.
As your Lord, please.
We,
Fifth, my lord, on a hearing. day in the
because of
Oh,
this
yes, yes.
time constraint today,
Not-
we are adjourning. Otherwise, you would have
past.
taken.
Issue is very short.
No, issue is short, but we'll have to carry it to the assembly. To write a judgment. For you, it's easy. You will argue and go home with 10 judgments. Isn't it, Mr. Goswami? With
No,
10
no,
judgments, you will go home.
I understand. My lord, can it be taken up on 4th, my lord? Will be the second date on reopening.
Fourth.
4th.
Others will be in the vacation mode and we'll do this. Yes. Most of the
there
lawyers
is
will be,
another vacation, not BU vacation.
so everybody will be in the vacation mode. So therefore, we'll have a time to hear this matter
Yes,
on that day.
Yes.
And we have also not much that matters on that thing. Huh? Already 6 matters are there, then we can finish it. Due to paucity of time.
Your friend will cooperate. No, I have nothing to cooperate. I have to argue the case. Why should I cooperate him?
No, we either
I mean,
will
the other side-
cooperate or his junior will cooperate on
Oh,
that.
yes, yes. They are always there.
Due to paucity of time, this matter could not be taken up. See, we have returned. Mr. B.T. Goswami, Learned Counsel for the petition, has expressed serious urgency. Accordingly, matter be listed on 9. No? City of time could not be taken up. However, as Mr. Goswami has expressed serious urgency, list this matter on 4th of January.
Oblige.
Your fighter,
What is this?
My lord, we have received counter affidavit of the rejoinder today, my lord.
regarding the has been initiated, I have challenged the authority to initiate the proceeding and also the manner of the proceeding.
Any stay is there?
My status quo.
Enjoy.
Not,
Any urgency, doctor?
my lord,
You are ready?
Today I have received
You are not ready.
rejoinder.
Okay. Mr. A.K. Dr. Learned Counsel for respondent number 1, 2, 3, 4, and 5.
1 to
1,
4.
2, 3, and 4. Submits that he has received the counter activity today itself. Accordingly, he needs some time to go through the same.
Yes.
Accordingly, matters stands adjourned and be listed after view.
Okay.
2023 after 24. Interim order passed earlier shall continue until further orders.
Oblige.
Lordship, we were about to file the affidavit and we have received the instructions, the detailed instructions. I think that here is we have, that we have initiated disciplinary proceedings.
Now he's not here.
He's not there.
So urgency.
Just one page.
Huh? Now what is your decision? Tell us, we'll not go through it.
Just 18th only we have initiated, so issued propose notice to the petitioner because he has been availing leave without any sanction, and that's why we have actually asked for a reply as to his insubordination, misleading information. But
Why are you after this man? Any serious thing he has committed or some? He says I am not well. Leave me. What is the allegation? Only not.
unauthorized.
He is saying that I am health is not permitting. Leave me. This is nothing but an ego. Let him go. If you have no allegation of misappropriation, if no allegation of any corruption, he says that please help me. I want to go on VRS. I will not disturb you. I am giving up my other benefits also because moment it's VRS, you will not get the whole pension.
Right.
So I am not fit to go there and you are issuing so cause. What is this? Is it a model employer? This is nothing but ego. Mr. Gogoi, advise your client properly. You are taking it up in 20 seconds. Yes. We are not liking this approach. This is not the way. Had it been a case that no, he has done misappropriated money, okay, even after retirement, we will continue with the department. Do that. Yes, Mr. Fukan. Is not it? Is this the cases for which people should come to the court? You want the VRS, he is not to the benefit of your department because he is regularly absent. Let him go. Issue so cause. We will set aside after few days, then pay all interest, full pension, everything you pay. Do your departmental proceeding. Is it in the interest of the government? You have the instruction. You are supposed to retire on 31st
January, ma'am.
January.
And
This is not the way to deal with an employee.
And they have initiated 5, 6, 7 Shukos Manor that I'm not attending to this one. I'm not well.
He is saying that I will go out. Please let me go.
Yes, madam.
Let him go. Who is
This?
this? Who is why this is happening, Mr. Gogoi?
My lord, but Shukos has been issued. That is my instruction.
We understand. Sukos has been issued. What is the Sukos? What is the allegation? That he is not attending office. He himself says, yes, I am not attending office because my health is not permitting. Let him go.
And August 3 months issued, they have accepted my VRS.
So he has sought VRS long back. There and say he is not coming. You show us the reason for not giving him VRS. This is not the way to deal with it. This is not in the interest of the department. We'll hold this person responsible. If government is to pay interest, individually, we'll record in this order. Next, on 22nd, we'll record that you proceed with the departmental proceeding. In the event it is decided that this proceeding shall go and he is entitled for pension, he will be entitled for interest from the date he has sought VRS till that is given, and that should be recovered from this person. We'll observe on 22nd. We'll do that. No problem on that. Yes, Pukon, advise your client properly. This court, under its order dated 15/12/2023, sought for information, sought for instruction regarding the status of consideration of the application filed by the petitioner for VRS. The instruction so furnished rather reveals that a departmental proceeding has been initiated against the petitioner for unauthorized absence. Whereas the case of the petitioner is that his health is not permitting him to continue with this job. Not continuing with the job. And accordingly, she sought, and for the said reason, she sought a VRS on 1/8/2023, and till date, such VRS, such application filed by the petitioner has not been attended to. Full stop. Subject to further consideration, this court is also of the prima facie view that when the petitioner has filed an application for VRS on her health ground, so that she is not been able to attend this court, there may not be any occasion to issue a show cause for unauthorized absence, inasmuch as the petitioner herself has intimated the respondent that she is her health is not permitting her to continue with this job. In that view of the matter, in the aforesaid backdrop, this matter stands adjourned and be listed on 22nd of December 2023, on which that specific instructions can be brought as directed by this court under its order dated 15/12/2023, if necessary, along with the records. Otherwise, this court may be compelled to ask for personal appearance of the Deputy Commissioner Kasar and Commissioner and Secretary to the Government of Assam, GAD. Oh no, already there is an order. They will have to appear on 28th.
So
Yes.
we have, this is our instruction that my lord, focus has been issued. They are contemplating a different, for that reason the VRS not been done.
Okay, we'll decide on 22nd.
What we will decide on that day.
Okay, we'll decide on that day, and you file an affidavit bringing this show cause, and with the ground that they cannot proceed.
Nobody gets the pressure, my lord. 1 month just retirement.
We'll say that whole premises is not tenable. Forget about that, whether you have challenged it or not. File an affidavit, bring on this on
I'll-
record. Okay. Obtain instruction. ইমান লিখিব নালাগে obtain instruction and it is their stand. So আগৰখিনি থাকক পিছৰখিনি নালাগে I'll just modify it. Mr. Roy, learned senior counsel, submitted, he may be granted to file an additional affidavit to bring on record the show cause.
Apply.
Prayer is allowed. Please be matter on 22nd. Mr. Gogoi, these are the unnecessary litigation.
I will come.
Is not it? A genuine case, government's interest is there. You fight it, no problem on that. But these are unnecessary litigation.
They should
Wastage of
decide
time.
my lord, end of October, my
See,
lord.
moment he seeks a VRS, he will not get full pension also. You are not getting his service. He or she is not coming. She is saying, I cannot. Can you bring her? It's like a restitution of conjugal right. Isn't it? Then he will suffer due to pendency. You will give him provisional pension.
It's just somebody's ego problem somewhere, but I don't.
What Thursday, but okay.
21st. Okay, 21st. Always want to be free on 22nd. But you be here, Mr. Babu, advise it.
But I'll if it proof, my lord, because I'll not get my lord to sign it.
Okay.
I'll prove my colleague or
Where is he?
he's in the Qatar.
You can.
So I'll bring it to record, otherwise, my lord, all the show cause,
No, affidavit will help us in determining
then I'll file through my colleague.
that their permission is to be difficult
That's
to give that permission. You notarize there and file it here
I'll type it.
because that can be done.
Yes,
If it
I'll
is
type.
notarized there, you can file it there.
I'll type.
You can file online even.
Okay, that's it. Public.
Yes.
For the last order, Lord, just to apply the honorable court. Yes, sir.
Extension officer under PNRD. Yes, Mr. Kaur.
Your lordship, the matter was placed before the cabinet. For my verbal.
Okay.
It was placed before the cabinet. Some queries were raised.
Okay, so it's not yet decided.
Not yet.
Okay. Mr. K. Kaur, learned additional advocate general, appearing for the state respondent, submits that though the case of the petitioner for regularization, case of the petitioner and similarly situated persons for regularization was placed in cabinet meeting. However, the final decision has not been made as certain queries has been raised. Accordingly, he submits that matter may be stand for 6 weeks. On the next date fix, he will obtain the up to date status. But the prayer is allowed list after 6 weeks. Or make a mention that it. Okay, list this matter on give a date. After view. 6th of February.
Yes.
Yes, Mr. Dhar.
Highlighting the state order
Record.
There are two orders. By this order, my lord, include order and again the state process found that the project has been moved from circuit. Here, right. But by
Okay, that police something like police
Yes.
constable.
Yes.
That two according to you there are two parts.
Yeah.
One is prior to from a specific period 5 years. What was a long period?
There were two disciplinary proceedings were.
Will it be possible to conclude today? When are you coming back?
I'll be coming after Poha.
Oh no, that cannot be. Why you will deprive us from your
So it don't
21st, 22nd may be difficult. most of it.
March. I will
We
take
tried.
much of your lordship time, my lord.
We will not take much time. I know that you are the counsel who finishes the matters in the shortest possible time. But it will take much time for me because the departmental proceeding will have to apply your mind. I recall one part you have been, it is regular.
Yes.
That is subsequent part. Earlier part, according to them, is
Yes.
not regularized, therefore you are done. Isn't it?
Remove.
You are removed.
So, my lord, the earlier part, by which I have been, that has been influenced. Okay?
Hmm.
But then it- Now, my lord, findings of the court, your lordship, my lord, at the bottom of
Yes.
page 45. In compliance with the, my lord, I read this, my lord, your lordship, find
I have marked also.
in compliance with the order of Honorable High Court, he was instituted on 7/10/2013. Either I was removed for your absence from 10/6/2006. Now, the was both Assam Secretary and Pahil work for protected doing the private department, but was initiating the departmental proceeding for one of the court. So that is the first proceeding, my lord, and my lord, I have been removed. Now, my lord, so far as my lord, unauthorized absence, my lord, 2006 to 2007, nothing has been mentioned. No pending. Now, fourth thing, my lord, say during the inquiry period while he was with the applicant Harispara, after doing he was granted 5 days of civil leave with effect from so and so, but he had overstayed in leave granted to him, and he was again discharged.
Do you have that record of this earlier proceeding?
Yes.
Notice was served upon him.
Notice was served.
Hmm.
He replied, first focus notice,
Hmm.
memorandum of allegation, everything was given, list of witness, list of documents, everything was given. He participated, inquiry report submitted. Thereafter, a final focus report was, focus notice was issued to him. He replied, it was not,
Are those not a part of the writ petition?
this in the original record.
Was
But I have submitted to the head to the
so your whole case is that it should be willful. It should not be
Yes.
willful. This is your case.
FR 73.
FR 70. This should
Yes.
not be willful. It's in a compelling situation. Then it cannot be said to be an unauthorized, and you relied on some judgment also. This is your case. Krishna. But it will not be possible to dictate at this court. Now I recall everything. Was your whole case is yes, I have participated, but there is no finding as such that this was willful. Moment it is not willful, I was prevented by my disease.
Order, what I find your lordship, there is discussion about my unauthorized method at all by the acting officer for method at the year 6/3/2006 to 27/2007 is concerned. The Executive Authority is discussing about my leave of absence from 4/9/2014. Now this period has been regularized, your lord. Now, my lord, 14/9 to third paragraph, your lordship, from 14/9/2014, he remained unauthorized absent, and my lord, ultimately, my lord, this period was from 14/9/2014 to my lord 23/9/2013. By answer the 9 letter or order, your lordship, that period was regularized. Fine. At page, my lord, 43, your lord. Letter where period was regularized, first period was noted, and no finding either of the inquiry officer nor of the disciplinary authority that was willful here. And FR it is
Mr. Gar will do it in a better way after vacation. At 4 will not be possible.
matter date. After vacation, I will be staying here for 2-3 months.
When are you coming?
After Bohag, April. It is a problem with what? I am in a problem. Are crashing.
You are depriving us of your service. No, no. Who says you have become? Oh, 74 is not a age. This is the place when lawyers are matured.
I think there would be no much.
22nd. Okay, on your request, we are fixing it. Let us see. We cannot assure, but since you are saying that you are going out, due to positive feedback, this matter could not be taken up. Accordingly, list this matter on 22nd. Keep this record. This will come to this court only.
It come get better about the path. The top of the boat here.
It will come. We'll see is situation, then we may upgrade your hearing. We'll see the situation. 21. Yes, Mr. Deuri.
I think the department of the inquiry report.
Not possible today. Due to paucity of time, that could not be taken up. Please this matter.
After
21. After in the last week of January 20. To me.
My presence may can be checked.
Huh?
My presence.
Okay. Yeah, his presence record is
Lord of
present. Yes. If I- It has been